this thing on? Hello? 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 Good afternoon, everybody. Welcome to the Crumbley Jury Watch. The Crumbley Jury Watch. I don't do jury watches, even though this is called the Crumbley Jury Watch. Because what are we watching? We're not even really watching them. We're just waiting. We're playing the waiting game. And the waiting game is really overrated. There's really not any excitement in the waiting game. When they come, they come. But yeah. What I did want, though, what I wanted to do was I wanted to discuss with you a few things I wanted to do. So I was like, all right, this makes sense to do this now before Drew gets back here. And I was on InfoWars. Those of you who are wondering, I didn't realize I was going on InfoWars when I got in there. But it was like just like a call-in type of thing because I was on X. So I was a little bit. It's a little weird. It's a little weird, but yeah, I was sort of very briefly on InfoWars. Did a minor plugging for my channel here, but yeah. Anyway, all right, I'll do my best. I'll do my best. All right. So while we're waiting for the jury, and I guess to be a jury watch, you kind of need to have the jury on in the background. So I'm gonna see if I can live stream that YouTube live stream. All of a sudden, like the verdict come out, and like 20 minutes later, I'll just be like, "Oh, okay, I guess that happened. All right." So, all right. Where was we? Yeah, I'm not seeing anything with the jury. Crumbley trial live. Let me see if I can find something here. Crumbley trial. I'm sure one of you will alert me if they say a jury's coming in. I'm confident that. But just so you know that it's on in the background here. That it's on in the background, and I'm not being completely negligent or reliant on others to get me this information. Let me share with you my screen here. I'll share with you my screen. That is what's happening at the Jennifer Crumbley trial right now. As everyone's sitting with bated breath, waiting, wondering. Ooh. I will tell you that supposedly it was a jury question, which came out where they were asking if they can draw an inference from the fact that Ethan never testified. What inferences, if any, can they draw from the fact that he did not testify? And I think they were told not to take any inference from it. I don't like that question. Because it sounds like they might be trying to infer that she would have called him if she thought it was helpful and she was afraid of calling him. But it's really hard to peek into the minds of the jury just based on a question. It's very, very hard. You do so that's prospecting at your own peril. So you think you have information when you really don't. Because no one knows what the hell is happening in jury deliberations. What I really want to cover with you is is this show. Before I go any further, I want to be crystal clear so there is no confusion. I don't want there to be any confusion about this. So I'm going to go on record publicly about my position about lawyer okay? He is not simply a smart attorney. I think he's an excellent attorney. Genuinely believe, and I want to be clear because sometimes I can be sarcastic. I'm not being remotely sarcastic. I think he's a brilliant attorney, brilliant litigator. I have learned a lot of perspectives from watching him. So I am a very big fan of Peter. I think that he's great. I think his YouTube content is great. Seriously. I know that he tends to soft shoe a little bit more in holding back his opinion about various things. A lot of you might think that, when it comes politically, he might be further left than I am. I don't care about that. What I care about is the dude is a phenomenal attorney, very smart, and has intellectual integrity. Like he doesn't have the hubris that a lot of other podcasters have. Phenomenal guy, phenomenal podcaster, phenomenal attorney. So even though it might sound like I'm disagreeing with him or whatever, I want everyone to know that I have nothing but deep respect for his abilities and his work product and think he's phenomenal. I really do. So I just wanted to get that out of the way. And I recommend, and you're saying you follow him. I follow him. And I recommend you do too, because I think that he does great work, really great work. Smart guy, very smart attorney. Yeah. And there is no but. There is no but. When I am dissecting this video he's doing, that is not an attack on him, even though I will disagree with him about a number of different things. That's not an attack on him saying that he's a bad attorney or that he's wrong. It's a matter of I want you to see how different attorneys who you may respect can have a completely different strategy or even perspective as to like what's considered morally appropriate. If not just morally appropriate, but actually disagreeing as to like what is the morally right thing for a lawyer to do in this circumstance. Specifically, I'm going to be focusing on the circumstance that Shannon Smith is in with respect to presenting her closing arguments, where he finds some of her approach more seemingly. My take of it is he seems to find some of it morally objectionable, whereas I look at it almost in the exact opposite end. Is I think it's probably perhaps her moral duty to frame certain arguments the way that she did. That doesn't mean that I am right and that he's wrong, or that he's wrong and that I'm right. It's a reflection of how gray this area is and how different well-meaning, well-intentioned, intelligent people can come to different conclusions about what is morally correct. So with that, let's get into Lawyer Knows breakdown here, and we'll review it while we're waiting for the jury to come back. I'm going to tell you right now, I watched, I don't know, like 90% of it. I got 90% of the way through. I wasn't able to finish it up. And a lot of what he says I agree with, but a lot I disagree with.
If it's a not guilty verdict, they're not going to appeal it anyway.
You see?
They can't.
I got all but the last 8 minutes. All right, so this is what we're up to. Let's take it from the top here.
Crumbley's trial end today. The case is not to the jury. It's not going to go to the jury until Monday. But we heard
he does a great job also, even in just finding clips to select. I'm telling you, he's an inspiration to me as to how I should produce work. I'm a huge fan of his work.
Heard cross-examination of the defendant and closing arguments. And that's what we're going to talk about in today's video. We're going to start with cross. I'm just going to summarize it kind of, and I'll play a little clip that I thought was not great for the prosecution and could backfire. And then we will go through the closing arguments in detail. I will answer as many of your questions as I possibly can. And I have a little something I'm going to read before we get to the closing arguments. We'll see how this video updates as we go, because as you know, with the timestamps that I grab, it's not always perfect when the video has not fully finished and restarted. So bear with me as we talk. But cross-examination of Jennifer Crumbley at the beginning of the day.
By the way, if the jury has not come back yet, tomorrow I plan on actually going through the cross and closing in full. I might even do some of it now after I go through his video. We'll see. We'll see how long I'm here, how long this takes. This is one of his longer videos. So
they talk about the text messages. Oh, by the way, I forgot. I was just reminded via the chat. Hit the like button, please, if you haven't.
He does this a lot, and this is a great thing to do that I need to do more. Hit the freaking like, especially on Rumble, okay? I'm going to start getting on you Rumble folks for not hitting the like, because apparently there it really, really matters. And I understand it's very hard to hit it. It's very hard to hit that Rumble, that like in Rumble, that thumbs up in Rumble. It's really, really hard, which is why it's not just hard when you're watching me, it's hard when you're watching anyone. And apparently that's why it has extra significance. It's like 1 like in Rumble is like 7 likes in YouTube. So if you're watching in Rumble and you can hit that thumbs up, I'd be much obliged, because they see that and they just start pushing me through the algorithm. So it comes to the top of the feed. Oh, Crumbley live trial watch. There we go. Otherwise, it's like I'm just like buried there. under like this avalanche. I can't breathe. It's terrible. It's terrible. So please hit the like. I'm going to do that a lot more during this. Every time he does it, I'm going to do it. It's a reminder to me.
Make sure you subscribe if you've subscribed.
Oh yeah, subscribing's good too. Subscribing's good too. And drop comments. He's going to talk about that also.
From the Crumbley case, and that's how you found the channel. Let me know in the chat, please. Love to hear how people come. Love to hear the different backgrounds and people that are from the community and who all comes in here and gives their opinion. I love to hear it. As many different opinions as we possibly can have is great. You guys are like jurors, and that's going to be important when we talk about the closing argument, how I might look at it a little different than you do. And we'll talk about all of that. So anyways, in the beginning of the day, the judge considers letting more text messages in. The defense attorney's like, can I at least read them? The judge is like, how do you not have them? Defense attorney's like, I delete them every year. All that stuff that seems pretty normal. At the end of the day, the defense attorney actually reads them and says, we're fine if you let a bunch in. And they're actually not that bad for the defendant. So they come in. Was not the biggest deal in the world, even though it is very shady whenever we get around potentially an involuntary waiver of attorney-client privilege by the criminal defendant when she
that always feels awkward.
Was on the stand. I thought the beginning of her cross-examination was a little argumentative with the prosecutor. And the prosecutor pointed out how she describes herself as a hyper-vigilant parent, even a helicopter parent. And again, that's from the jump from opening. I thought it was interesting that they created that burden for themselves, basically, even though the defense has no burden, of course. But to say she's a hypervigilant parent, now
I disagree with him on this. This is the first place that I disagree with him. And in general, what he's saying is 100% correct. In general, what he's saying is 100% correct. But I'm going to let him finish his thought. I'm going to explain to you why I disagree with him about the whole hypervigilant mom type of thing. I'll explain to you that after he goes through this.
You have to prove that because the state's going to try to prove she wasn't. And he mentioned it in his cross-examination, spending all her time on money, time and money on horses, going out to bars, and then, of course, with her affair. They've hit the affair a million times. I think they...
Now, he said that he doesn't like the fact that they tried portraying her as a hypervigilant mom. Well, Shannon Smith tries portraying her as a hypervigilant mom. They call her a helicopter mom, as if she's always like swirling around her son. They are 100% tax deductible. That is not legal advice. That is moral advice. For legal advice, I suggest you talk with a lawyer. Also, you're in Canada, so Canada, just forget it. They're going to tax you for... You've been taxed 9 ways to Sunday already. I can't tell you anything about Canada law. Okay, so I want to explain the hypervigilant mom thing he's saying. And what he's saying is correct. In general, you're right. Defense has no burden to prove anything. They have no burden to prove anything. And when they start throwing out here, she's not an average mom. She's a hypervigilant mom, implying like she's practically super mom, which I don't think anyone's going to see Jennifer Crumbley and think super mom. I don't think anyone's going to have that takeaway. Okay, let's be real. I mean, no woman who's having an affair, that right away is going to take you out of being super mom. All right? No woman who has an affair and whose kid ends up shooting up a school is going to be considered super mom. That's just not happening. Okay, you lost that competition. However, the reason I disagree with Peter about this, it's not that they're trying to prove that she's a hypervigilant mom. To me, when they're raising her hypervigilance, the point is to change the nature of the discussion in the jury room. So if the nature of the discussion is she a satisfactory mom versus an unsatisfactory mom, well, then you're falling into this whole 50-50 gray area. But by trying to stress over and over again, she's not just an average mom. She's not someone whose eyes are half closed. She's hypervigilant. First and foremost, there's 2 reasons I think this was a good thing. Because calling her hypervigilant mom just means that's her parenting style. That's her parenting style, that she's the mom who's always like, get in your room and crack the books. I think that there's a lot of weaknesses in claiming she's a hypervigilant mom, and sometimes you don't want to present arguments which are transparently false. And that, to me, is the best reason. to say that they shouldn't have tried portraying her as hypervigilant mom. But I do think that she seems to be a very hands-on type of person. When she describes her personality, she describes herself as someone who, like, when things are stressful, I close off and start dealing with things that need to get done. That's someone who feels like, okay, let's get things done. The fact that she did well in her job is reflective of being organized, not someone who's just flighty, loosey-goosey the way her attorney is, right? That she sort of is on top of things, which makes you feel like she's the type of mom who likely one would expect before she has any kids. You tell me she's going to have a kid, I would project that she likely is going to be all over her kid. And I think that's what they're trying to portray. And there's a lot of, and they present evidence to support that notion. The reason I like it, the reason I think it could be a positive in this context is because if you can manage to shift the debate into the jury room of is she or is she not a hyper vigilant mom? Is she actually really a hyper vigilant mom or not a hyper vigilant mom? You've already won. That's already a win. Because it's like, no, she's not a hyper vigilant mom, but not being hyper vigilant doesn't mean that you're a terrible mom. You're just not hyper vigilant. If so, it's a way of changing the language, changing the structure, changing the nature as to what the entire debate is about. So it's not like they need to win in improving to the jury that she's a hypervigilant mom. That if they lose that in the jury room, that the jury sits down and like, do we think she's a hypervigilant mom? Let's have a show. She's never going to win that vote. She's not trying to win that vote. She's trying to shift the discussion into the consideration that, wow, not only is she not just like a terrible mom, she's probably like a hypervigilant mom, like maybe your mom was. A lot of us have moms who are like that, who are like all over us. That that's the one who's like carrying the stick in the family compared to the dad. So I think that's not a terrible thing because they're not creating a new thing that they need to prove, which I think that Peter, a lot of the reasons I disagree with him is because I think that he's coming back to his knee-jerk, this is what attorneys in general, litigators in general, how they approach something, and he adds tremendous value in giving that insight from someone who's an experienced litigator who's telling you this is how we think through things. And I say to myself as a litigator, do I want to have to try to prove something that I'm not obligated by the law to prove? I don't want that burden. I don't think that's what's happening here, though. And that's why I think he's mistaken. Because I think what they're trying to do is I think that Shannon's trying to shift the conversation from is she satisfactory or unsatisfactory into is she hypervigilant or not hypervigilant? And even if she's not hypervigilant, that doesn't mean she's unsatisfactory. She's still that. It's like, even if we're talking about her being hypervigilant, clearly she's satisfactory as a mom and therefore should not be held liable for Ethan's conduct. So I think that changing the focus of that conversation is what the objective is. And I don't have a problem with it. I think I personally disagree stylistically. I think that's not a terrible thing at all. I think it's actually a pretty smart move because you don't need to win and convince them that they're hypervigilant. You want them to just be considering maybe she is a hypervigilant mom. Maybe she's not a terrible mom. She's even a hypervigilant mom. Oh, no, she's not quite that level. But certainly she's not a terrible mom. Disastrous mom. Leading to deaths of kids kind of mom. So I think changing the nature of the conversation is it's not a bad move. It's really not a bad move.
Made their point. My question for you is, as we listen to this cross-examination, do you think they went too far? Is there ever a point where you started to feel like the generally bad guy rule is applying to Jennifer Crumbley? They're trying to pile on. They're trying to slander her, drag her name through the mud, do everything they can to make her look like a bad person, and therefore more culpable here criminally because she had an affair or did some things that are...
I think this is an interesting cultural question. And I don't know the answer to this. I don't know if I have my finger on the pulse of American culture enough. I can tell you this. I'm an old man. I'm a very old man. I can remember Gary Hart. And most of you don't remember Gary Hart. Okay? Gary Hart was considered the leading DNC candidate in the 80s. I think it was when Dukakis ended up winning it in 1984. Or not, in 1988. Like the leading candidate for the Democrats. And he was... there was an affair that he had, which was exposed, where he was on some boat, which was ironically called Monkey Business, with some, I don't know, intern or woman, whatever, secretary. engaging in a dalliance while he was a married man. And this was such societal taboo that he was destroyed politically. Less than 15 years later, less than that, a decade later, the DNC is giving a pass to Bill Clinton for engaging in dalliances, multiple dalliances, while he's sitting in the White House. And obviously the society has changed more and more into being more accepting, tolerant, and no big deal from where we were in the 80s to where we are today. So I think that he could be correct on this. I think Peter is likely correct on this. That when you're sitting here trying to portray her as a terrible human being because she was engaged in extramarital affairs, yeah, in the 80s, that would have been very powerful, very effective. Today, I don't know. I don't think so. I think a lot of people are like, yeah, everyone's having an affair. I think that's how a lot of people look at it. I'm not, and you're not, but like, we know about a lot of people who are cheating on their spouses. We don't look at that as that makes them a terrible person. Whether that's a culturally good thing or bad thing, that's not what I'm weighing in on right now. I have my own thoughts on that, but that's a recognition of where our culture is at. So if that's where our culture is at, and we can expect that a jury is going to be mirroring what our societal culture is, I agree with Peter on this. Pounding on this and pounding on this and pounding on this, pardon the pun, is probably not in the DA's best interest to say, oh, what a terrible human being. Oh, what a terrible, terrible human being. Now, I might think she's a bad person. I might think she's immoral. I do. I don't think she's a good person. But so I don't think she's guilty here. But I probably feel more strongly about it than most people. Likely more than most on the jury.
Are nefarious or immoral. Do you think they pushed it too far? Because I always wonder if it's irrelevant. How far do you really go into it? Once you make the point that she cared more about her personal life than.
And just to push his point even further, what Peter is saying, and in agreement with him, I look at it as being terribly immoral, and I wouldn't care about this with respect to convicting her. So someone who's looking at it less objectionable morally, all the more so they would just sort of shrug at this and wonder why the DA is trying to humiliate her this way. You start feeling sympathy for her at a certain point.
Her son, I think that's fine, but here's where they went and pushed a little too far, in my opinion. But I can't wait to hear what you think, and we're gonna listen to part of it together.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. It included other individuals.
Yes.
What's adult friend finder?
So we can go on and meet people who meet certain tastes that you're looking for.
And so she asks what adult friend finder is, the attorney, the prosecutor does. She, I think, gave as good of an answer as you can. You're looking for people that have the same interests as you. What does this have to do with Ethan Crumbley? What does this have to do with what she knew?
Good question.
What does this have to do with her negligence, her gross negligence as a parent? That's the trouble for me. It's bad. It makes her look bad, sure, especially bad to her husband. But it's really not, to me, something that, and they pointed out in closing then, Shannon Smith points it out in closing, how they're going after her for all these reasons to make her look bad. And
I mean, obviously, I think they're trying to imply she's a narcissist, only cares about satisfying her own appetites and needs, and rather than taking care of the people that she should be taking care of, like Ethan. But I think a lot of people are going to be thinking like Peter's thinking.
It seems like this was a bit of a reach and unnecessary. And we'll listen to the exchange here during the objection, which is always interesting, and people have a lot of questions about always.
And you had the app, Adult Friend Finder, on your phone.
I do not believe I had the app.
Okay, it was found on your phone.
Okay, well, I guess it was on my phone.
Okay, and there were messages from you to other individuals.
Correct.
And she seems I'll tell you something else that's bad for the DA. What's bad about this cross? She seems sincere. She seems embarrassed about it. She seems sincere. She's like, I don't have it on my phone. And when he's like, what was found on your phone? And he's like, oh, okay. I forget. It makes almost like it was so insignificant to me that She seemed sincere that she didn't remember she had it on her phone, which is implying it wasn't an important part of her life. Right? I mean, to me, that's how she comes across, at least.
Your Honor, I would object that this is going outside the scope of the affair with Ryan, but
I don't think the court's ruling on opening the door was.
I agree with that. Because it was one affair. It wasn't necessarily, you know, all of her charades she may have been running out on her husband. And I think they did push it a little too far on the court's prior ruling.
Should have asked that earlier.
But the state's position is the door was open. We're going to run through it.
Should have objected to it before, as soon as the, you know, the adult finder thing was brought in there.
Just her extramarital affair with Brian Walsh.
Well, I guess with regard to Mr. Walsh, I determined that the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having.
Exactly. The judge is like, I don't think she opened the door to this. And then again, as Shannon Smith seems to be winning this argument.
Yeah, I don't think the DA did a great job. I haven't gone through the cross yet. I plan on doing that later or tomorrow. I'm not sure when, depending on whether the jury gets back or not. But I do plan on looking through that cross after I finish going through this video.
She does some things that just make you scratch your head a little bit, how she makes some jokes here.
One extramarital affair for about a 6-month period of time, where she met with him one time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
Also, I might add that argument in front of the jury is horrible, should not happen. I don't know if they allow this in this courtroom with this judge and all that, but to me, that would be my number one issue on appeal. The prosecutors kept saying things like this, making statements of fact that they're going to impeach her. She said something yesterday that they can discredit, and they have evidence to discredit it, and they want to get into it right now in front of the jury.
This is where Lawyer by the way, shines, and this is one of the reasons I'm a fan of his, because he makes great points that you wouldn't think of all the time. And this is a great point. He's right. This is an appealable thing. You're sitting here and you're making your arguments in front of the jury about facts that are not in evidence, but what you're going to do, or that we have evidence that she's lying, which is what's implied here. He's great. He's right. Spot on.
I think that's totally improper. Totally improper.
it's pretty exciting.
She said it's kind of exciting.
Hi.
All right,
It is what it is.
all right, well, go ahead. But
I won't delve too far.
Okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect your time, Judge. I'll be brief.
My own gosh.
So,
And then Shannon Smith says, we might all blush. It's like, I feel like you could have won that argument. You were in that argument, and it's just kind of strange. But I'll say, when we get to her closing, Shannon Smith has a kind of style.
Autistic. I don't know. Maybe she is. Maybe she's autistic. Yeah, that's a stupid thing to say. He's talking about how his affair, how her client is having affairs left and right, and she's throwing out there, we might blush. Maybe she's trying to make a joke to try to lighten the gravity of what her client has done, but it doesn't land, and it just sounds, what the hell are you talking about? Why would you say such a thing?
And this is her kind of style. You guys will let me know if you like it or don't. I posted on my Twitter, my X, if people liked it or hated her.
I think her closing was great. Great. Certain things I didn't love about it were mostly style of presentation more than the words that she was saying. Whereas Lawyer, and several other attorneys have a lot more problems with the words that she was saying. My biggest issue with her is that she comes across, her tone is very aggressive sometimes. Her tone is just very almost like attacking the jury, which, that's something that lawyers need to learn to sort of dial back. And we know you're feeling passion for your client and for the client's defense, but it's like, you never want to come across like you're about to jump over jump over that railing and threaten to choke them to death if they don't vote not guilty.
Her closing argument, or mid, about 50% hated it, 25% liked it, 25% thought it was mid. So there is a split.
50% hated it. I think that's crazy. I think that's very harsh.
And I think it's possible that the jury, because she has such a strong style and personality, that some do really like it. Some probably really don't like it. So, that's really where it comes down to these kinds of comments where the prosecutor now responds with, it's not a laughing matter. So he's pointing it out to the jurors that probably don't like her, but all it takes is one. As a criminal defense attorney, all it takes is one. Kelly, yeah, it's not evidence. And I think that there was too much of that. There was too much of that.
And I think that his audience, Peter's audience, is far more likely to be leaning in favor of the state than my audience is. I think that a lot of them are leaning that way. This trial needed Judge Toll. This is such a typical comment. Like I saw an hour of Judge Toll, and now I know everything about Judge Toll as being a great judge, which I didn't even think that Judge Toll was that phenomenal. I mean, there was good cross there of Judge Toll was in South Carolina Murdoch rehearing. There was a few good moments there when she had the clerk on the stand, which that was really good. But some of her legal analysis was just, I don't really know where you're coming from here.
Vicky said this trial needed Judge Toll. It would have looked very, very different if this was Judge Toll. Very different.
Probably.
This is Crumbley. I'm sorry, this is not a laughing matter. This is Crumbley. An adult friend finder. We see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021?
No.
August the 11th of 2021?
No.
And more importantly, November 21st, 2021?
No.
Okay, and more important than that, November the 28th, 2021?
No.
Okay, you don't dispute that evidence under.
I don't dispute it.
Okay, so they got into the fact and they proved that she was on Adult Friend Finder. And I didn't know. Okay, so call me ignorant or a prude maybe. I thought it was for her to meet up with people like Tinder, like you try to hook up with people or whatever that you meet on there. But the defense attorney clarifies in closing that it's when couples want to add somebody into the mix.
I think that's by the time he's done, which only goes to show that she did a great job to me. You know what I'm saying? Like they don't like her, but I think that she did a great job.
Which again, I didn't know that until the defense attorney explained it. So sometimes
You're
going
correct.
even further to explain them.
Even Peter here seems to lean more and more towards not guilty as Shannon Smith is going further along, while at the same time he's chastising the way she's doing it, which is an ironic thing when you consider what's her goal. Her goal is to make people think not guilty.
Some things can be difficult or not go over well. Kay asks, hi, Peter, I sent you an email with a link of a video of the defense attorney turning around and blatantly flicking off someone in the gallery. I saw that. Somebody sent it to me on Twitter. It's so packed today. I'm not sure I'm going to have enough time. If I have enough time at the end, I will play that clip. A bunch of people tagged me on it in Twitter too. Lori, Peter, do you think the act of buying a troubled 15-year-old a handgun is enough on its own to rise to the charges of, or to involuntary manslaughter charges? This is the ultimate question, Lori.
But then how do you, at what stage is someone troubled? Which kid is not troubled on some level? Which adult is not troubled on some level? We all are dealing with challenges.
This question we are going to break down when we get to the closing arguments as to how each.
Because when you look at one end of the spectrum of troubled, the deep end of troubled, then yeah, if the person is like, clearly psychotic, and then you're like, here's a gun. Yeah, I think that could rise to involuntary manslaughter. I mean, here's a gun. Go do whatever you want with it. Yeah. If it's someone who's like, not popular and frustrated with that, and you get them a gun, and I don't think at all.
Side is explaining exactly what Miss Crumbley's actions were and how they fit into this statute. Because the state spells it out. We're going to hear exactly what the statute is, exactly what the standard is, exactly what the elements are, and see if the state, in fact, proved it. Gringa said hypervigilant.
This is precisely the point. And I'm noticing you're not the only one who's saying this, Mrs. Smith. A lot of mothers are saying this, that she really hit the hammer. She hit the nail that she hit the head of that nail with that hammer squarely, with a lot of the stuff that he finds objectionable. And I'm going to explain to you why I don't find them objectionable. Why I don't, but we'll get there.
To say she's a hypervigilant parent, now you have to prove that.
All right, what happened?
The state's going to try to prove, but refused to pick her kid up from school the day he called. I get it. The jury is not deliberating right now. They're going to start on Monday.
He did this on Friday.
Lil Patty was a helicopter parent. It's somebody that is always around their kids, like a helicopter, always around your kid. Chronic Christie said it has to do with where all of her time and attention went to. You can't claim to be a helicopter parent when your attention is living a pineapple lifestyle. Is that what it says? Pineapple lifestyle? Casey, say what.
And I want to just reiterate, and I'm probably going to say this so many times it's going to annoy some of you who are here the entire time, okay? This video that I'm doing right now is not in any way, shape, or form a takedown on Lawyer You Know. I like him. I recognize that he is a very intelligent, experienced, great litigator, great YouTube content creator, everything about him. I've personally learned a lot from him. This is so I'm telling you right now, I love his work. I have deep respect for his intellect and his abilities as a creator and as a litigator. Great insights. Everything. I'm telling you, I think you should sub up to Lawyer You Know. I do. Okay? This is not a takedown on him. The reason that I'm doing this video is to show you how two intelligent litigators can look at the same case and see different things. And that doesn't mean that I'm right and he's wrong, or that he's right and that I'm wrong. It's a matter of, I want you to appreciate that this is not science. This is an art. And that different artists will look at how to best approach this and what steps we should take to convince a jury in a completely different fashion. And that the resulting work product will be very different. So this is not at all, just to reiterate, I don't want anyone to think any less of Lawyer You Know after watching this video. If anything, you should have more respect for him.
What you want about SS, it was brilliant how she gave the prosecutor a list of witnesses and only called JC. State wasn't prepped to close today. So we're about to get here right after cross-examination. The defense rests. The state seems surprised. The defense is like, and we're ready for closing. And some people applaud that, and that's fine. And that's the defense's prerogative. But I remember in the Parkland trial, when the defense did something similar, the judge was ticked, the prosecutors were ticked, they were scolded, people acted like there was some kind of ethical violation. So it goes kind of both ways when how you talk about it. And I will just say, there is no duty.
And that's an interesting thing, the whole playing games with your witness list. And a large part of it is you sort of feeling, it could be from the defense counsel's perspective, because they gave a long list of different witnesses. Then they bring up Jennifer Crumbley at the start, and then like, we're sitting, done. All the other witnesses, done. We're not bringing them. Go to closing, to sort of put the pressure on the state to give a closing when they're ill-prepared to do so. So, but that can tick on, it's an obvious, it comes across as you're playing games. The judge sees it. You have a risk of annoying the judge. At the end of the day, your objective is to succeed in convincing the jury more than the judge. The jury's perspective ultimately is much more important to you than whether or not the judge is happy with you. So in that sense, is it gamesmanship? Definitely. Is it kind of maybe? And it could be also that if she does terribly, I think he's going to mention this, if she does terribly, you might want to have other people help repair her so she's not the last thing that the jury remembers. Not that I think it would do much to repair her. But if you think she does well, you're like, you know what? Let's send it out on a good note. This is a great note. Let's send it out here.
To tell exactly what you're going to do at trial. There has to be witness lists. You can't call people usually not on your witness list. You can't lie. If you know something's going to happen, but if plans change, or maybe she thought, and a lot of times this is what happens, just to let you in the mind of a lawyer. You call your client as a criminal defense attorney and they do a really terrible job. You like to have a couple other witnesses just in case, so it's not the last thing the jury hears. If they do really great, maybe you think it is the last thing I want the jury to hear. Maybe she thought her client did great and she was like, you know what? I don't want to mess it up. I'm not going to call any other witnesses. That's possible as well.
Even though bringing another witness afterwards is really not going to, if she did really badly.
She doesn't deny that he asked his parents for help and asked them for the 9mm because he already had a different gun. She could work from home, but she didn't. She used messing around as the excuse all the time, but she never took him to a therapist. The picture that he drew was clearly concerning, and she did not tell the school that he just got that kind of gun, that he was a little depressed that his friend just left, all of that, which again, they'll reiterate in closing. They went to a Halloween party. He stopped bowling. She never met any other friends of his age in 2021. He wasn't in any clubs at school. All of the classic signs basically the state wants to provide to say he was depressed. You should have known this was coming. You should have known this was happening. Okay. Now we're going to get to the state's closing argument. They start with the brutal facts, as sad as they could possibly be. And then they get to the standards. So let me see.
And this part that he's doing now, I just want you to know, it is so,
All right, so
this is where there's a lot of homework which is required behind the scenes on finding the moment that you want to get to, and then and doesn't always queue up exactly as you want. It's one of the more challenging parts of being a podcaster.
I'm going to hear them talk through involuntary manslaughter, what they need to charge to get this, and then we're going to try to apply the facts to this law and see if it's possible that we get there.
Perceptions of that. I want involuntary manslaughter. She is charged with. This case is based on 2 theories. You're going to have all this in the jury room, but hopefully I'm going to explain it so well you will have no questions. These are
Here it is that we can all look at it. Gross negligence in the performance of a lawful act, or gross negligence in failing to perform a legal duty. And she's going to explain them now. We're going to talk about it. We're going to talk about the facts, and we're going to answer the question that was asked earlier. Is this enough? Buying a troubled teen a gun. What does that mean? Where do we get to the line that it is a troubled teen? Number one. And that was, I think, Shannon Smith's main point in her closing, is every teen could be considered troubled, right? So where is the line, and who's going to tell us where that line is? And number two, buying him a gun. I've gotten a lot of messages from people around this part of the country saying hunting, and Shannon Smith brought it up, girls having, holsters or whatever under their homecoming dresses. And to me, buying someone a gun or showing them how to use it, is it their gun? They try to argue on the defense that it wasn't. He could just use it. Prosecutors argue they bought it just specifically for him to use. We're teaching him how to use it, things like that. So what does buying a gun mean for somebody, especially if it's a teenager? And what does troubled teenager mean? Those are the big questions we've got to try to determine based on the facts we have in this case.
dependent on 2 specific theories. One is it gross negligence in the performance of a lawful act, and that gross negligence caused death. And in doing so, the act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. 2, she knew of the facts that gave rise to the duty. 3, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then 4, the death of the victims was directly caused by defendant's failure to perform this duty.
So if you look in there, there's a lot of willfully neglected, grossly negligent manner. But the really important thing I want us to focus on as well is the defendant. This defendant, Jennifer Crumbley, caused death. Her willful neglect to refuse to perform her duty.
And this is a great job that he's doing to basically point out how superseding causes, intervening factors are so critical to this case, and why it is that's why it has to be gross negligence. It has to be such gross negligence that it's foreseeable, that it's almost like this isn't an intervening factor anymore. That it's like, this is just obvious this is going to happen, right? I mean, if you have a kid who's really psychotic, and a lot of you, and a lot of this whole question about like the troubled kid, and I just want to pause in this here and just make this point to you. When you have a kid who's like really an obvious lunatic, their lunacy becomes much less of an intervening factor. The fact that they act out that lunacy becomes and does something that most people wouldn't do is much less of an intervening factor, because it's like, hey, look at this kid. Dude's a psycho, right? I mean, he's bashing his head against lockers. He's always beating up other kids, whatever. He's waving his gun around all the time. He's always talking about how he wants to kill everyone on the planet. That type of like psycho. He crushes pigeons for fun. He has a collection of dead squirrels. So, when you're talking that type of psycho, zero friends, all these different things that we tend to associate as red flag, red flag. Oh my God, you see this kid and anyone seeing him walking down the street is like danger, 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 danger. And then the parent does nothing, or if anything, makes it easier for that psycho to do something by giving them a gun. You can understand how that psycho doing psycho things is not an intervening factor. That's predictable. It would be surprising if he doesn't eventually do it. Maybe not today, maybe not tomorrow, but at some point he's going to do it. So you can understand how that's less of an intervening factor. The more the kid is successful at manipulating, at hiding his psychotic inclinations, the more gross and terrible your parenting should be before anyone should even consider bring charges against you. Because how the hell can a parent know? How can any mother know that you're going to hold them? That's something that's an intervening fact. And that's why these two elements, as far as really play into each other, really in an important way, as far as understanding philosophically what's a healthy approach for looking at this whole situation, in my opinion.
Caused death. It was directly the cause of the death. Now, not the only cause of the death, which the state will bring up later, not the only cause, but it was a direct cause of the death. JB asked, Peter, do you think the state met their burden beyond a reasonable doubt? That's something I'm going to ask you guys, but I also I'm going to give my opinion as we kind of do this together and unpack it together with the facts and the law in this case. But it's not a oopsie, I left the door unlocked kind of thing. It's gross negligence. It's willful neglect, and it has to directly cause the death. And that's why we talk about the difference between civil negligence and this criminal involuntary manslaughter theories and elements that have to be proven beyond a reasonable doubt. Melanie said, what is her legal duty? Here it is, Melanie. This is the legal duty as a parent or as anybody. It could be as a boss. It could be as a teacher. It could be as a truck driver, whatever it may be.
I really want to move along past his super chats into his analysis of the trial. And he adds some important insight there, but I really want to get to his perspective on the trial. Okay.
Shots at Sun, shot Madison.
Putting him in any clubs at school? Is it the 2 rooms thing and not cleaning his room? Is it the affair? Is it the horses? Is it the job? Is it she didn't take him home at school or she didn't hug him at school? What is it that crosses that line? And how do we know that and determine it as a society going forward? That's the big question.
You heard the evidence that the defendant's shots at Sun, shot Madison Baldwin, Tapier, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendants asked.
Yes, we are still waiting on the jury. In case you're all wondering, by the way, I have it on in the background right here. I'll turn the volume up in case anything happens with the jury. But you can all hear this audio. There's no audio going on there, but you'll hear the audio if, in fact, there's someone comes into this room, either with a question or anything like that. You'll be able to hear it, even though I switched tabs over to this one. So.
Of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these 4 individuals was.
And he's watching like at 1.5 speed.
Now you look at that, all of that I have to prove, and it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following 3 things. 1, that she knew of the danger to another. She knew there was
a lot of people asked for definition of gross negligence that I gave last night. So here is the definition in Michigan given to this jury.
Which is, it's still very amorphous because it is amorphous. It has to be amorphous. Because you need to cover a wide array of different type of scenarios.
more than carelessness, it's a higher standard. Willfully disregarding, saying, I know it's a problem and I'm going to choose to disregard this problem.
I like the way he fixates on that. That's a great way of phrasing it. Yeah. I know there's a problem. That's exactly right. Yeah. This is why I say it. Well, you know, he's great.
Situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury. And to a reasonable person, it would have been apparent that the result was likely to be serious.
Well, I don't see how we get to this step 2, where it says first the defendant knew the danger to another. What danger does she know of to others? Nobody knew of dangers to others. She knew the situation required to take ordinary care to avoid injuring another. I don't understand how she knew. This is why the intervening factor is so important. Yeah, if he was an apparent psycho, that everyone saw he was a psycho and a danger to others, that he gave signs of that, yeah. But that first step there is really lacking. I think the second step is lacking too, but but those two, that first step to me, that's the end of it right there. That's the end of the analysis. The defendant knew the danger to another. The school didn't know of it. And to say that the school wasn't sufficiently concerned about it to even ask whether he has access to a gun. Even though they know he's looking at bullets. Why is he looking at bullets if he doesn't have a gun? Who the hell looks at bullets if they don't have a gun? Yeah, I want you to just ponder this for a moment. Have you ever seen anyone who doesn't own a gun looking up bullets? Like, why? Why would you be doing that? Clearly, you have some level of familiarity with guns and ownership of guns. And what if you're looking up bullets? It's very unusual to me. So for the school to not have any inkling that he had access to a gun is ridiculous. And let's imagine this scenario here. Let's say they hadn't gotten him a gun. Let's say he had gotten the gun from a friend of his, or he found the gun somewhere. So would the school be less reckless for not even asking him, hey, do you have a gun? Do you have any weapons at all? They think he's suicidal when he draws that picture. So we need to ask you this question, because you're displaying signs that are concerning that you're going to hurt yourself. Do you have any weapons? And see how he responds. They didn't ask him that question. They didn't ask the parents that question. If they ask the parents that question and they lie to cover for him, then you start getting into there's an intent there for them to try and enable him. But they never asked him that. They never asked him that question. They never asked Jennifer or James that question.
I told you I have two theories. We're prosecuting and charging based on two theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's two alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony.
This is a good question here. Peter, is ordinary care, it says it an illegal term. I think you mean a legal term. Yeah. And again, reasonable person standard, ordinary care, what a reasonable person would do. It's like, we got to define this stuff. And we're going to see in the defense's closing argument.
That's why she makes the argument the way she makes it. That's precisely why she keeps hounding on comparing herself to Jennifer, to try and plant the seed in the minds of the jury that they should also compare themselves with Jennifer, because this is so amorphous. So let's just think about all the things she's doing, all the things about this situation which are parallel to our own lives, to consider whether or not this is reasonable care. This is a major consideration as to why I like Shannon's closing, and I think the way she handled it was completely appropriate. As far as the word she said, I think that her tone was off at times, but I think the words she was saying were spot on, and you could see how compelling her words were, and the fact that 65% of his audience, and a lot of mothers here, are saying that they heard that closing, and they're like, yeah, that could be me.
How she tried to define it. Again, in their closing, the state said that the shooter learned to shoot from their parents. And I made a note. I would make sure to point out how the state said it looked like Ethan was showing you how to stand while you
Yep.
shot at the range. To
He knew
Jennifer
more about guns
Crumbley.
than she
Again,
did.
James Crumbley is a separate case, and guess what? The defense did bring that up. The state talks about how they can try to point the finger at James Crumbley all they want, but she made posts about giving the gun to Ethan as well. And then here's another point that that they make here to try to make Jennifer Crumbley look bad based on her prior text messages. I can't find it. This is annoying. I can't wait for this video to update. But that he was a oopsie baby. He's weird. She said that to a friend. But the prosecutor, John, are you putting comments up? Sorry. So, sorry, Shannon Smith. Sorry, counter. Prosecutor admits you don't have to be with your... Oh, this is why I wanted to play this clip. But she admits in her closing argument, which I thought, as soon as we heard Shannon Smith, it opened the door to this. But the prosecutor even admits, this prosecutor in her closing, you don't have to be with your teenage son every second of the day, only if they show signs of mental illness. To say it like that, to me, was one of the most concerning parts of this entire closing argument in this entire case.
And he's completely right about this. What a ridiculous thing for an attorney to say. This was stupid for the DA. Stupid. So as soon as your kid shows any signs of being troubled, it's your job now to be around them 24/7. Really? And what stage is it that they're showing signs of being troubled? Because every kid is troubled on some level. So it's your duty to be around them 24/7. And if you're not, we're going to send you to jail. It's almost like that's what the district attorney is creating such a high hurdle for parents, higher than they need to. And that's what makes it stupid. That's what makes it stupid. You can say that there's an increased level of parenting that it becomes necessary, naturally necessary, that a reasonable parent would take when they see their kid is troubled. Yeah, that's fine. But to imply they need to be around them 24/7, otherwise we're going to send you to jail if the kid does something wrong, is Lulu nuts, cuckoo bananas. And it's a stupid move by the DA.
So who is going to draw that line? This prosecutor, this judge, the government, state, federal?
And why should the jury even have the authority to draw that line? It's ridiculous.
Who is going to draw the line about when you do have to be with your teenage son every second of every day?
It was a great catch by Peter.
What mental illness? What level of mental illness? Do you not take your kids to get help because then you admit they have mental illness and now you've got a higher standard or burden as a parent? I don't like that. I don't like that kind of
it's unnecessary. It's
description
stupid.
by the prosecutor that
it's a loser.
If somebody is depressed or goes through time of depression or anxiety, especially as a teenager,
it's a find him not guilty. Please find him not guilty because I'm insane in the yardstick as to what I'm demanding of parents type of argument.
that now there's some kind of higher burden.
I wish Shannon jumped
now,
on that.
Guns, I don't want to get into the politics of guns and who should or shouldn't have guns, but if they're illegal and it's not illegal to have your son who's a teenager shoot a gun at a gun range, where do we draw the line for that? How do we determine where it crosses the line? Now, again, some of these are philosophical discussions, and I can understand, and I think it's so incredibly fair for all of you guys in the chat to let me know that you think this case does cross that line. Where is the line? I don't know. But
one of the reasons I'm so fascinated by this case is because it draws philosophical conversations as to what a healthy society is, what a role and duty of a parent is. And I think this is such a fascinating thing that this is something that faces every one of us at a certain point in our lives, or 95% of us at a certain point in our lives.
Crumbleys are way past that line with the pictures, the journal, the dead animals, the comments he made, the depression, how they treated him. If you want to say that this was far across that line, that's fine. but I just don't like the state attorney or district attorneys trying to tell parents their duty changes because their kid has anxiety or something like that.
And I agree with everything he just said. I agree even stronger than he's saying it. I think it's not just that it sounds like it's filled with hubris, but it's also a loser. It's as a legal strategy. It's a loser. It's a complete loser because of the obvious hubris that's inside that's baked into it.
I think all that's going to do is make people stop getting help because they don't want to get labeled that, which is already a thing in our country.
And that's something I hadn't considered. And
then later
possibly,
they talk about how why'd she delete a bunch of messages? That's shady. Hopkins, a school official, says the parents weren't interested, but basically he felt bad for the shooter. They didn't hug him or say I love you or greet him in any way when they come in. I don't care their house isn't clean, but there was barely a place for him to sleep. That's one of the arguments that they make.
See, here's the thing. I think her poor parenting, Jennifer's poor parenting, is that she didn't make Ethan clean his own room. But that's her job to be Ethan's maid? What the hell is that? No, her failing to, in my opinion, and this is not really case related, but it's more a matter of the reflection of her failing as a parent, is that she didn't force him to clean his own room. Say, no, you basically not getting your whatever, you're not getting your PS access to PS4 until the room is clean. Whatever it is. We're not going shooting. Clean your room and then we'll go shooting. Your room's clean, then we go.
And guess what? To me, why put in all the mess?
And part of that is, and by the way, it's not simply because it's out of sympathy for mothers, which mothers have a hard enough job as it is. It's not simply that. It's also your duty as a parent is to teach this kid to grow into someone who's a functioning adult. And if you don't make them do their own legwork, like maintaining themselves or their environment, are you going to shower him also? I mean, you're going to like put the food into his mouth? Oh, you didn't put food into his mouth. No. The idea is teach them to grow from being a helpless infant into being a functioning adult. Part of that is learning that they must take responsibility for their own hygiene and the hygiene of their environment, like cleaning your room.
Why make it look like horrible living?
Judge is back. Judge is back. That's what we're hearing. People are saying Judge is back. All right, let's see what we got.
Place that restriction of the court and not be permitted to be spoken to by anyone, right?
Yes, sir.
All right. Any preference, 2, 3?
If that's so reliable, Your Honor, I'd say 3. Can we approach her?
Sure.
Thank you. I assume they're saying there's a verdict coming in, right? Let me share this out so people know a verdict's in. No, those are fingers. Those are definitely still fingers. It's not a verdict. I got my volume up. You can all hear the white noise. Could be closing time. Seems like we have a verdict.
Good afternoon, you may be seated. I know you guys have all had an exciting day. You've completed puzzles, done Sudoku. I heard one of you was sleeping on the floor. I won't name names. I'm so sorry. Hopefully you realize the reason behind it. Okay, so here, the 12 of you have not come to a verdict yet, so they're going to be returned tomorrow. But life happens, and in the event that one of those jurors was indisposed, we would need one of you to fill in for them, and they would be instructed to start deliberations all the way over again. So that's the reason for it. That being said, I'm going to dismiss 3 of you by blind draw today. Actually, I shouldn't use the word dismiss. I'm going to have 3 of you.
That was a
not
jump
return
in
tomorrow, but you're still
there.
sequestered.
Yeah.
You understand what I'm saying? So some of these people sitting out here would love to talk to you, but they are not allowed to talk to you and you're not allowed to talk to them. And it's the same as every day when you leave here, you're still sequestered. I just think that you would prefer to be doing your laundry or going to work or doing whatever it is, but I still have to trust you to not discuss the case. All right? Are there any questions about that? But I'm gonna have 2 of you come back. And
You're
you've
right.
already ordered your lunch, so I'm hoping the 3 of you ordered something you like. No? No?
My question is, if we are one of the 3 that go home and spend the day at home tomorrow, how do you know if will you call us as soon and let us know what to do the following day?
Absolutely. I feel bad enough that I feel like I kidnapped you. Okay, so I feel bad enough that you're here. I know that you know why. Okay, because when this is all over, I'll tell you stories about strange things that happen and
No verdict yet.
jurors and, just life happens. So, as you know, this is a very long, emotional and frankly expensive process. To start over would be devastating for everyone in the room. So.
Decide what to do with the rest of the jury
I
now.
feel bad,
The
but I
ultimate.
would feel worse if we didn't have enough jurors to finish deliberations, okay? So 3 of you, I'm gonna pick three numbers by blind draw, and then you can exit, and they're gonna take you down to your car. And we have your phone numbers.
Pretty much.
You are still sequestered, all of you, and the other 2 have to return back in the morning, okay? And I'm gonna tell you again that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. So do not.
No
go on
watching
social
Good
media,
Lawgic.
Don't post anything, don't go on Facebook, don't do research, don't discuss the case with anyone, whether you're at home or at work or here spending the day with me again, all right? So I'm gonna pick 3 of you by blind draw, the other 2 have to return at 9 o'clock in the morning, all right? All right. Juror 17, you can be sequestered at home. Juror in seat 4, you can be sequestered at home. And juror in seat 10, you can be sequestered at home. All right? You can bring things with you. You're 9 and 15. Jurors in seat 9 and 15. I mean, obviously you can't bring a newspaper or something like that. You still can't research the case, but if you have work, you can finish my crocheting for me if you know how to crochet. Anything like that. I know it has to be really boring, but I think you understand the purpose. You can't talk to anybody. Again, a lot of people here would love to talk to you, but none of you are allowed to talk to the press or discuss the case with anyone. All right? And we do have your phone numbers. So I'm going to release you to go back to Judge Anderson's jury room, and then you're going to be escorted out of the building. And then the two
Hopefully
remaining
after this,
jurors
she'll
will
tell us
come
what's
back
happening with the
on
jury.
top. All right, any questions about that?
These are just the
Okay.
alternates she's addressing now.
Appreciate you. Thank you for understanding.
All rise for the jury.
Okay, now I'm going to read another jury, and if you can all be seated.
Doesn't seem like there's a verdict yet. Does not seem like there's a verdict. Because they're sending home alternates. It sounds like they're probably going to let the jury go for the day. These alternates were already picked. There were 5 alternates. But they decided instead of making all 5 of them sit around, we're going to leave it down to like really 2 alternates and have the other 3 as like backups. But those other 3 able to like go about their business and not supposed to talk to anyone in case they're ultimately needed. After the court closes, I'm going to address this comment.
All rise for the jury.
My thoughts on this.
All right, so I'm going to have you come back tomorrow morning. What time are you? 9 o'clock?
Do we like 9?
9 is good.
9 o'clock? Okay, you're going to return tomorrow at 9 o'clock. We appreciate your efforts. We appreciate you taking this seriously. This is very serious, as you know. And I need to tell you that during the trial, do not read, listen to, watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth.
So clearly they're
and
sending the
lawyers
jury
must
home.
cross-examine them. Because of news reports.
And this is standard instructions that she's giving them now. So while she's giving these instructions, and I'm not going to close out of this in case there's anything said to attorneys, but this is just standard jury instruction to keep the jury self-sequestering while they go home for the night. But they're definitely going home for the night.
Get a good night's sleep, maybe sleeping on it will help you, right? Stay healthy, we appreciate you, and we'll see you at 9 o'clock, right?
All rise for the jury.
She looks terrible.
I'll let the jury go first.
And I'm going to continue.
Both sets of jurors.
I'm going to continue my dissection of Lawyer You Know's breakdown after this. After she sends them home.
So we'll see you at 9 o'clock in the morning.
Yes, thank you.
Just gonna make sure.
Thank you, Judge.
Yeah, you.
Imagine being in Jennifer Crumbley's shoes right now. You don't know if you're going back to jail for the last night of your life or for the first night of the next 25 years. You have no idea. But I do want to weigh in on this. So I think a lot of us lose perspective of what it must be like to be sitting in this particular jury box. So I want to give some perspective on that. I think they're done. You done? I just want you to consider this. Oakland, Michigan was rocked by this shooting. And it doesn't help that after those lives are destroyed, friends, family, neighbors, or friends of friends. So these are people that, you know, if I don't know them, I know people who do know them. Entire community rocked. And then for the next couple of months, all these questions about what's happening with the parents. Are they going to be held guilty? And it seems like they're on the lam in all the news reports that they're running away from the police, and are they going to be found? I mean, this was a hot story, the story in Oakland County. Now, you were living in Oakland County, you experienced all of that, and you're sitting on a jury here. You likely walked into this having pretty negative feelings towards Jennifer Crumbley. Pretty negative feelings towards Jennifer Crumbley. So you can understand, to me, if I'm sitting here watching this trial from inside the courtroom, I would be expecting that a not guilty would take a while to happen, because there's going to be a couple of people who are very hesitant to let her walk, because they have baked into their psyche, based on their own circles, that, hey, I got to go home and face family and friends who all hate her and think she's terrible, and say I found her not guilty. And I spent the last 2 years thinking that she's a terrible mother, terrible person, and it's her fault this happened. So to undo that takes some time. So I think the fact that they didn't return a quick verdict is probably best for her. That doesn't mean she's going to prevail. But it means at the very least, if you're Jennifer Crumbley, you take some solace in the fact. This seems so sad. This seems really sad to me. Just watching her leaving chains. Seems really sad. So there you go. Okay, so I think we can take some solace in the fact that they're not coming back with a quick verdict, because I would think that this jury probably started with a strong anti-Jennifer Crumbley tilt, and that the defense must have done something sufficiently well to have a couple of them say, no, I'm not convicting this woman. Right? I mean, that's how I take this. I could be wrong. I mean, we're all speculating, and my speculation on this is arguably no better than anyone else's. Being an attorney doesn't give you added insight into this. You know, it's all just I'm trying to argue from a perspective of common sense rather than litigation experience. So it's not like because I'm a lawyer, I have better insight into how this jury is thinking. I have no idea who's on this jury. Anyhow, I do want to continue sharing with you where I disagree with Lawyer You Know. Those of you who joined late, I want to be clear here. This is not at all a takedown of Lawyer You Know. I have great respect for him. Think he's a phenomenal person, which is most important element. Great YouTube content creator. Very, very smart litigator. Really smart. Really good. And I watch him frequently, and I recommend everyone else should as well, because I think he's great. The reason I'm doing this is to show you that even intelligent litigators can look at the same circumstances, the same trial, the same work by an attorney, and come to very disparate opinions about the work that's being performed, because this is not a science, it is an art. And it's basically the art of how do I convince 12 people that my client is right? And how far is appropriate to push? How far is appropriate to, where are those lines, the right lines to draw? And this is something that every attorney struggles with internally all the time. Every case, you're like, where is the line? How far do I go? And what is going to be most impactful? And that's artistry. And artists are going to have different opinions. That doesn't make one artist right or wrong, because frankly, a different 12 people, that if you present the same argument to these 12 people, it may be that his direction may be far more powerful. Whereas you go to a completely different 12 people, my argument would be more powerful. So that's why I'm saying this is not at all a takedown lawyer. No, the reason I'm doing this is out of respect for him, because I think he's a very smart attorney. And I want you to appreciate that this is not science. This is art, and I'm explaining to you the rationale of understanding human psyche as to why I disagree with him. But that doesn't mean I'm right. I'm just telling you what my experience tells me. But Joe is cult leader, which means he has a lot of perspective. It's not a cult. The following people who sub up to my channel are followers. They're not followers of me. I'm not the leader. And this is not at all a cult type of cult. Not at all a cult type of cult. So let's get into his assessment of the work. He's about to get to Shannon Smith. He's almost done with defense with the states.
Quarters and situations. Because I do think that they were trying to make her look like a bad mom. I really do.
Oh, they definitely are.
I really do.
And they have to.
Okay, one of the other most important parts of all
they have to, because if she's a good mom, then where's her guilt? So they really have to.
This 5:30 is 2:50-ish. Okay, so is what Jennifer Crumbley's knowledge was prior to the shooting and after the shooting, because that's one of the biggest questions to me. What did she know? Because if she didn't see the journal articles, if she didn't see the text messages, if she didn't know about the animals, then that's difficult to say that she does have the duty.
The building and the art studio where Jennifer Crumbley was found. He's far away from. And it's what she knows, what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland, he's lonely.
Oh, wait, she did it one time.
Sometimes she said, I'm a failure as a parent. The message to her son's friend's mother.
And the messaging that the state wants to pass on by the whole oopsie baby thing is she never wanted this. And since she never wanted it, she never really accepted the duty of being a parent.
He's kind of depressed.
Which is crap. It's just crap. Because probably half of America are oopsie babies.
In April, she texted them. And then the messages from her son. The messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke. But I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text?
That's a call for attention. That doesn't mean because he's making a joke. Not a call for attention because he's about to go shoot up a school.
As a joke. And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why.
This is so
She was
stupid.
just messing around.
So stupid.
But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in car, I never even thought like he would have any mental issues. Like,
there is no verdict yet. Jury went home.
Any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Lowe, she's never done anything wrong. Jennifer Crumbley said a lot of things about that drawing in that meeting at school. She sent the drawing to James, and Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees.
Right. I really want to get to Peter's analysis of Shannon Smith, because I'm not looking to just pilfer his work here. You can all check out his work, and I recommend you do. But I do want to get to his analysis of Shannon Smith, because this is where I'm going to have the most disagreement with him stylistically as to whether or not Shannon Smith handled this well.
And there's a lot more about inserting what you believe or know to be true in your own personal opinion here. But first, here are things that are inadmissible in closing, ethically speaking, and are objectionable. Okay. I want to read all this before we play the clips so you can have this frame of mind for reference as we talk.
Now, this is very, very, very important here. What he's going to read off to you are Florida's rules of ethics for making closing statements, because that's where he practices. He practices in Florida. And I need to make something clear to you so you can understand what I think is happening here and why it is that I think Peter reaches conclusions that I do not reach. He's about to go through the rules of ethics as to what you're allowed to do versus what you're not allowed to do, and the lines, and based on that, assess Shannon Smith's work. One of the reasons I disagree with him is because he is approaching this from the Florida's specific state guidelines, which are different from New York, where I practice, and different from Michigan, where this trial is being held. And the differences are become very important, very important. So he didn't pull up what Michigan's rules are. And I think that he's done so much trial work because he has so much experience that he just sort of, when you're doing it for a while, this just becomes like, this is what's natural. This is what's normal. This is what everyone understands. Everyone understands that you can't make this type of statement. You can't make that type of statement. If you're an experienced professional, these are things that you know. So it almost becomes like this is what practice is. You start thinking this is what legal practice is. And I think this is what's happening with Peter here. I think that he's seeing her violate Florida's rules of ethics. And to him, he's like, what kind of attorney would do that? Who the hell would do that? This is totally wrong. And he's not fairly accounting for the fact that this case is being tried in Michigan. And Michigan seems to have far more relaxed rules as to what a litigator can say in closing arguments than those that exist in Florida. And accordingly, since he's so used to operating by Florida's rules, when he sees what's happening in Michigan, he's like, what the hell's happening here? This is crazy. Which makes sense. Makes sense because he's a highly experienced Florida litigator. So I understand why he comes to that conclusion. But we have to assess Shannon Smith's work in the jurisdiction that she's operating. She's operating in Michigan. And in Michigan, I'm going to pull up for you what the rules are in that state because I pulled them up. And I was like, I wonder what they are in Michigan. And I actually found them. So let me pull them up here for you so we can look at them together. Because he's going to go through what the rules are in Florida. And there are a couple of rules that in Florida that don't seem to exist in Michigan. Okay, let's hear his rules for Florida first.
Stating personal beliefs. Lawyers may not advocate their personal beliefs during the closing. They can't.
This isn't what we have in New York either. There's no bar on stating personal beliefs. Now, in New York. So they have this in Florida, and I'm positive he's right about this. Okay, because this is a guy who does this all the time. So I'm positive he's right about this. Stating personal beliefs is not something that we consider objectionable in New York. In Florida, you cannot do it. I'm positive he's right about that. But that's not something that exists in New York.
Use words like I think or I believe.
We do that here. We can use I think or I believe here in New York.
That is objectionable. Next, injecting the attorney's personal experience, commitment to the case, or sacrifices for the case. They can't evoke sympathy. Saying things.
Now, these are rules which are far stricter than they have in other jurisdictions. So when he's used to these rules, that explains it. But let's hear the rest of them.
Things like, I've lived with the burden or carried this case and it's made my.
In fact, before we go further, I want to pull up what Michigan has. Okay, let's pull up Michigan. Here's Michigan right here. These are rules for Michigan. 4 things. That's it. Make this a little bigger so y'all can see it. Why is this not center? Okay. Closing arguments are meant to help This is civil proceedings bench book for the state of Michigan, where this case is being tried. Closing arguments are meant to help jurors understand the evidence. After the close of all evidence, parties may make closing arguments. Plaintiff is entitled to make the first closing argument, blah, blah, blah. We don't care about the scope of closing arguments. Counsel may only make arguments regarding facts and issues that have been elicited during the trial. Okay, fine. So it has to be about stuff that's elicited during the trial. In making a closing argument, which you can argue that she slightly goes beyond this, when she starts talking about, like, you know, stuff in her personal life. So she slightly pushes that boundary. I'll give Peter that he's accurate in that. In making a closing argument, counsel permitted to draw reasonable inferences from the testimony. This is not long, don't worry. This is relative. It's like one page. So he said, an attorney's used the phrase, I believe and I conclude, was permissible. So you see specifically what you cannot be saying in Florida, because Peter just told us in Florida, you cannot say, I believe, I think. But in Michigan, they expressly are allowed to use language like I believe or I have to conclude, which is the same thing as I think. So you can see how there's already disparate rules here between the way closings are conducted in Florida versus Michigan. Respectively, the defendant has the right to ask the jury to believe his case, however improbable it may be, whatever, fine. Remarks designed to invite sympathy from the jury. So you're not allowed to do that either. It's a reversible error for the defense to ask jurors to consider the effect that judgment will have on them personally. Now, when we talk about sympathy here, that's the impact that the verdict, their judgment, will have on them personally. We will hear comments from Shannon Smith talking about how she's personally sacrificed for this trial, or that her house is in disarray, or that things are going crazy back home, which imply that she has sacrificed herself for this trial. But that's different than saying, if you don't find her innocent, I'm gonna go broke. She's talking about stuff she has sacrificed already, not the impact it will have on Shannon Smith going forward if she loses. And it seems like that is the only thing that's prohibited in the state of Michigan. This is a very important distinction. When we're analyzing her work and the things that she says in closing and the propriety of those statements, this is a very important distinction. It's impermissible for an attorney to use rhetoric that attempts to inflame passion and prejudice and that intentionally subverts the jury's fact-finding role. And we'll talk about whether or not she does that. It's important to argue that nobody would go through this pain and suffering for any sum of money. That's really more of a personal injury type of case. Remarks involving witness testimony. You cannot make personal attacks about the integrity. This is all rules in the state of Michigan. And these are the these are the rules of the game that in the environment that Shannon Smith is operating. And I respectfully submit that it's not simply Shannon Smith's duty to comply with these rules. It is her duty as a zealous advocate for her client to go as far as she possibly can while comporting within these restrictions. You have a duty to, as zealously as possible, advocate on behalf of your client. And this is where I sharply disagree with Peter, because and others who have commented on this, not simply Peter. And even though I admire Peter, respect him, and I think he's a phenomenal litigator, because she's operating in Michigan, because the rules in Michigan are different, I don't think that she's merely allowed to do things in Michigan that she would not be allowed to do in Florida. I think she is ethically and morally obligated to do so in her zealous advocacy, to the extent it will help her client. And she's following the rules of Michigan, even if it would be breaking the rules in Florida, because we are all duty bound to advocate on behalf of our clients as zealously as possible. You take a look at the rules, you see what the rules prohibit, you see what the rules do not prohibit, and you stay within those guidelines and say, anything that's prohibited, I'm not going there, but anything up to that, if it's helping my client, I'm definitely doing that, even if it would not be allowed in another jurisdiction. And I don't think that's simply something you're morally allowed to do. I think it's something you're morally obligated to do. And that's where this is where I have my strongest disagreement with Peter in his assessment here. You also can't talk about you can't attack the honesty and integrity of opposing counsel. Okay. These are pretty lax rules, especially when we hear comparison to Florida. I feel like New York is in between Michigan and Florida on these rules, because Florida sounds very restrictive, far more restrictive than what we have in New York, and that Florida seems like there's just like there are a lot of guidelines as to what it is that you're not allowed to do, but the point that I'm making here is Shannon Smith's operating in Michigan, and since she's trying to practice law in Michigan, it's her duty to follow those rules and go all the way up to the line if it's going to help her clients. And this is that's why I really diverge from Peter in his assessment here, as he's going through the list of rules that they have in Florida. Lady Lawgic is showing me all the different boxes she got for me to send out these autographed hats.
Is that awesome?
It is awesome. It is awesome. Thank you. You are awesome.
I should earn my keep.
You more than earn your keep.
Life so difficult. They can't fake emotional breakdowns. I'm not saying she did that. It's just another thing in here. Murphy v. They cite some cases. Attorneys should be afforded great latitude during closing argument, but they.
And yes, I understand that. He says he doesn't know Michigan. And all I know about Michigan is basically what I just showed you now. Someone asked me whether it's different for criminal, or someone threw a comment out there. It might be different criminal. Maybe. If anything, it's probably more lax in favor of the defendant in criminal. It's probably more lax. It's almost impossible to believe that it'd be stricter on a criminal defendant, where we try and protect them from being wrongfully imprisoned. Great point. My point that there's a difference between civil and criminal. That's certainly likely true. But if anything, it would almost certainly. I haven't found the criminal guidelines, so I don't want to misstate anyone here or misdirect anyone about what the standards are. My point is, it's difficult for me to fathom that it would be more, that the rules for a defense counsel in a criminal case would be more restrictive than they are in a civil case. If anything, we're far more likely to be more lax in what we allow them to do. Give them broader range in what they can do and say. These are great comments you guys are raising here.
Must confine their argument to the facts and evidence.
Mm-hmm.
A lawyer shall.
And that's the one thing that I think that she sort of strays from when she goes beyond that. That's a fair argument.
Not in trial allude to any matter that the lawyer does not reasonably believe is relevant or supported by evidence. They should not assert.
Now, relevant versus supported by evidence are two different things, because they don't mention relevance really as much in Michigan.
Personal knowledge of facts or issues, except when testifying as a witness. They should not state a personal opinion as to the justness of the cause, the credibility of a witness, or the guilt or innocence of the accused. Their personal belief. This case condemned a closing argument that the law has been used as an instrument of oppression and exploitation. That starts to get to jury nullification. Another counsel, you cannot comment on your own background, where counsel argued that he went to Vietnam and thought he had seen it all. But then there was this case.
Florida. See, that's Florida.
Additionally, an attorney cannot assert personal opinions about the credibility of the witness, the justness of the cause, the appropriateness of the charges based on personal experience.
All right.
Okay. And that's just a few from literally one article on the Florida Bar website. And there's a lot more about inserting what you believe or know to be true in your own personal experience that has not been filtered through.
That's not what Michigan seems to have, though. And that's a very important distinction. Very, very important distinction. Because that's really the heart of what Shannon Smith's argument is.
The proper.
And I'm going to go further, and I'll point this out. It's not only what her argument is, it's what her argument must be. It is clearly the most effective argument to make. And the reason that in this particular context, it must be her argument is because we are dealing with amorphous standards. We are asking the jury to put themselves in the shoes of what a reasonable parent would do. How can anyone come to judgment as to what a reasonable parent would do without looking to themselves? It's impossible. It's impossible. It's literally not possible to try setting yardsticks for appropriate behavior of any person without looking at how you behave. And in the context of being a parent, it's appropriate behavior for a parent. So she must do that if allowed by the ethics of making closing argument.
Channels as to something being relevant and admissible evidence. And that is potentially the problem here with some of what Shannon Smith said or did or argued during her closing argument. I'm not going to say it wasn't effective. I'm not going to say there weren't people that probably really liked it, because I think there were. And I felt myself being like, yeah, it's a good point. It's a good point. Yeah. Yeah.
And that's why she had to make the point.
Maybe one, but some of them were like off the reservation, cringy. Some of her own personal experiences that she tells us about that we're about to listen to. Let's jump to 616 here. But keep that in mind as we hear where she goes with this closing argument. She starts out with the normal stuff: beyond a reasonable doubt, defense doesn't have a burden, highest burden in the land, poster board similar to Mark Eiglar's that we saw during his closing argument. I liked all that. But then we get to inserting herself. And a lot of people said it made her personal to them. It was relatable. It was a good argument. That's kind of exactly why it's inappropriate. Another one is the golden rule. We all know that. You can't ask the jury to put themselves in the defendant's shoes.
How can you not in this context? You see, I don't understand this. I don't understand this. How can you not? This is not a case where she pulled the trigger. We're sitting here. I don't understand this argument that he's making at all.
Sometimes it's tiptoeing on that line if you say, I could be sitting in that chair, because you're trying to make them think so could you.
Yes, you are.
And that's
Yes, you are. And it's very effective.
That's inappropriate.
I don't know why that's inappropriate, though. See, I'm not getting why that's inappropriate. In Florida, yeah, I can understand why it's inappropriate. But in Michigan, I don't think it's inappropriate.
But guess what? A lot of this is really only a problem if the prosecutor objects. I thought at certain points it crossed the line.
That's true too. That's true too. Sometimes you push the border, you push that boundary and see whether or not you get an objection. And if you don't, you just keep pushing it. You just keep pushing it. I talked when I was covering the rehearing of Murdoch. So I was talking about how when Harpootlian was crossing the clerk, that Waters kept trying to object, and that the strike zone and objection was overruled. And I pointed out that you sort of get into this zone where the judge is an umpire calling balls and strikes. Is this sustained? Is your objection in the strike zone, or is it out of the strike zone? And that when you start missing over and over again, the judge, when even there's a borderline moment, will likely call it a ball and say overruled, because you just sort of establish that you're just objecting in situations you should not be objecting to. So this is probably another one of those situations. Similarly, if you see that in this case, as far as issuing an objection from the defense attorney, that they're letting you get away with stuff, so you start broadening that strike zone as to what's allowed. You start over here and it just starts getting broader and broader. Oh, okay, you're not gonna have any issue with that, counselor. All right, let's see if I throw it 3 inches off the plate, whether you're still okay with that. Oh, okay, you are. Let's go 4 inches off the plate. You start going wider and wider because you feel like, you know what? If they're gonna let me do it, I'm gonna do it, because it's powerful stuff.
Judge should have stepped in.
Now, I don't want anyone to walk away from this thinking that I think Shannon Smith did a perfect job. My biggest issue with her is her delivery is a little bit too like, rah. She's just like sounds so angry that it's a turnoff. And I think if I'm turned off by it, and I'm probably rougher from living in the Northeast here and being in New Yorker my whole life, more used to people being aggressive. And if I'm noticing it, I have to imagine that other members of the jury are probably feeling it as well. They're sitting in her face. So, and they're probably not raised in the Northeast, where we're used to people being kind of jerks or kind of loud or kind of abrasive. And she walks up there.
But she didn't. So at this point, the jury heard it. That's the latitude criminal defense attorneys are going to get. And if it's not guilty, They're not going to be able to appeal because of this.
That's true. Great point.
So the arguments that hit, even if they were potentially inappropriate, defense lawyers sometimes like to push the lines. And I think that she was arguing hard for her client. If I was the prosecutor, though, I would have objected 100 times. I don't care if somebody got annoyed that I was objecting during closing. This is not the way you're supposed to argue. And that's why I said it was cringy to me. Not because I didn't think they were effective. Some of them were effective. But I was just like, how is this happening right now?
Judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience.
By the way, I just want to point out, you guys can talk in the chat about anything you want to talk about, anything at all. Seriously, go ahead. Have a field day. I'm just saying this. I'm covering the Crumbley trial. That's all I've been talking about for the last hour and 46 minutes. And then this happens. And I'm like, how much space in your head does Trump have? It must be like a very empty skull that this is where he's just like skating around in there. I don't get it. I don't get it. All of a sudden we're talking about how are we coming there? It's just like a big like multi-level suite that he found inside your head. No charge.
Audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown.
By the way, she also mentions keyboard warriors, memes, TikTok, etc., which I thought was really interesting knowing. Maybe she didn't know, I don't know, but now we know the jurors are going home for the weekend. She mentions social media, the media at large, the accusations, the publicity multiple times. And if you remember back to the Johnny Depp Amber Heard case, they were very careful about even mentioning that stuff because they didn't want to put it in the minds of the jury to go home and start searching stuff. But she kept talking about there were memes about her and all this stuff. And I hope no juror does it. But this is why we try to stay away from some of that when we're actually talking to the jury, because guess what? Those aren't facts and evidence. Who testified that there are memes out there? Who testified about the keyboard warriors? Now you can make argument, you can make inferences, but we got to be really careful about what we bring into closing arguments.
So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say.
So again, her tone and everything here, I know he's playing it faster, which probably makes it worse. But her tone is just very easy, girl, easy. You know?
I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry.
And again, most of what she says, I'm like, wow, great choice of words. Great point. Great job on this. Great. But her tone is just very like chalk. It's like on a chalkboard. You just hear the nails scraping.
This whole trial. And all I'm saying is that I'm human. I am a human being. And so is Mrs. Crumbley.
So I will say one thing, minus the TikTok stuff. Her talking about what she did in the courtroom, I'm okay with that. You know, saying I'm sorry a lot, messing up, fumbling around with exhibits. I'm totally fine with all of that. It's when she starts to go into her personal life about what happens with her kids and her husband and basically making herself the expert on parenting and what is normal and is not normal and is okay.
I don't think she's making herself an expert on parenting when she's doing that. I think she's just displaying herself as a typical reasonable parent. And that's why I think it resonated so effectively. But I don't think that's laying out a yardstick. See, he's implying that it's almost like she's pretending she's the expert, like she's some sort of testifying expert witness. I don't think that's what she's doing. This jury is about to go into deliberations and start trying to figure out what does a reasonable parent do. And she's giving an example of what a reasonable parent does via herself in a way that's very relatable, likely to many people in the jury box.
It's not okay. She's trying to find the line for the jury to where it's appropriate or where it crosses the line into even being criminally culpable for something your child does. And she's trying to push that line as far forward as possible. The problem is she is not an expert witness testifying. And that is problematic. And which is why you're not usually allowed to argue like this in closing argument. And I say that, and I say not usually because she was allowed to do it today. So there you go. It's not an all or nothing, always never kind of thing.
And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt,
See,
bad with
and this
technology.
thing, this super chat, or not even super chat, this chat he brought up, if they had secured the items, perhaps this could have been avoided. That's not the standard that the jury is supposed to be judging. That's the point. It's got to be gross negligence, which foreseeably leads to this outcome. Because if this is the yardstick, then yeah, of course she's guilty. Of course she is. But this is not the yardstick the jury is supposed to be considering. This is the yardstick we're afraid they're going to embrace. But this is not the yardstick that they're legally supposed to be considering.
Why you're not going to see me touch that laptop.
Totally fine. And I think endearing.
So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't.
That's where I was like, oh, I didn't even pick that up. It went right over my head when they were talking about friend finder or whatever.
Get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that.
And by the way, this, I think, is a great point. This is a great point that she's pointing out, that she wasn't afraid to stand here and face you and face the face cross-examination in front of you. Thank you, Paul Youngs. Gifting memberships. We always like that. That's very cool of you. Thank you, brother.
With all kindness, because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got
pretty sure here, this has nothing to do with facts and evidence. And Peter's about to say that this is okay. So I think even Peter intuitively understands that when we talk about that you're supposed to talk about facts that are in evidence, it's not like a very narrow thing. You can go a little bit afield from that, even in Florida, apparently.
My wife sent me that meme as well. But also, I think totally fine. I think that's a great cultural reference. I think it makes her point. I loved that.
So you see, that's what I'm saying is even Peter here seems to be recognizing that's not facts and evidence. That's not anything. That's her own personal experiences as far as memes that she's seen. So, and I think that we're starting to display that it's not quite so rigid that it has to be facts that are in evidence, as long as it's relevant. And that's why I think much of her stuff falls into a similar category that he finds to be outside the scope. And I think the reason he finds it outside the scope is because he has so much freaking experience litigating, but that his litigation has been largely, if not exclusively, in Florida, where they have much more rigid rules.
That is the type of stuff you can bring into a closing argument. If you're going to talk about memes, right? There's a meme or whatever, not memes of what's going on in this trial. Not this trial is being blasted out there on social media, and not going into my personal life outside of it, using those examples. Again, I think that's a great point. I think that's a great use, a great argument of a meme. Izzy, this is another big point. When the defendant testifies, the jury's going to look, and what do they think about the defendant? They looked in her eyes, they saw her, and they're going to make a decision based off that. Wicked Maine. It feels like she had an inkling of what was going on, but chose to do other stuff to avoid it. So is that enough? Is that enough for her to be culpable and convicted and guilty of involuntary manslaughter in this case? If she had an inkling of what was going on. And this is your perception if you were a juror, but I want to know, is that enough? Do you think that's enough? And other people, if you agree that she had an inkling and chose to avoid it, is that enough here?
To be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my.
Matthew Felty apparently found the Michigan criminal bench book, says no new evidence by defense in closing. Okay. That's the only reference. The rest is limits on prosecution. Like I said, it's going to be broader for criminal, if anything. Thank you. Thank you much.
Wait, running out the door, putting on my makeup as I drive to court in my car, because my life is not perfect and no one's is. And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok.
By the way, I want you all to know, it's funny here, just as a complete aside, and I think this shows insecure in her part with the argument she's about to make, but we'll get to that. As an aside, I let Peter know that I was going to be doing this beforehand. So, because I didn't want to, I was like, I don't need to start drama if someone's going to start saying Joe's attacking Peter or whatever. Like, I was like, I just want to give you a heads up that this is not at all takedown, but it's just a reflection of different styles and things of that nature, which I feel good with the work product so far, that I've been very clear about what my objective is here. But he responded back to me, "Do your thing, Joe. Hope you're well." And then I said, as an aside, who would I have to bribe to get you on for a show? And during this stream, a half hour ago, he said, "Haha, nobody." But that he's been really busy. So, yeah. Anyway, I don't know if you're watching now or not, Peter, but good seeing you, brother. And thanks for checking back with me.
Talk about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family.
And again, that's the Harpootlian. We've seen lots of lawyers, Letitia Stalk. We've seen a lot of lawyers make that exact argument. I think that's great. And we talked about it last night, that I think she should make this exact argument. It was clear that she was paying attention. Now it's very clear that she's paying attention to what's going on outside the trial, a lot of the media coverage, and minus if you plan on making TikToks about me again, I think those comments are inappropriate. I think it's a great.
I don't know if it's inappropriate. I mean, it's just not, there's no benefit to it. There's no benefit to it. And all it does is just makes you look cowardly, like you're afraid of people doing that. It just is. There's no upside to it. So
Great argument for her to make. You might not like me because I think if you're looking at this jury of, I think 17 people are sitting there, 12 plus the 5 alternates, some of them probably love her. Some of them probably don't. You want to make sure the ones that don't hold it against her.
Agree totally.
Vicky says she still doesn't like this attorney.
And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me.
This is true, and it's a great point. It's a fair point. He is playing her fast, and her cadence sounds more aggressive in high speed. That's true.
On Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am.
So Jules, again, you guys are the best. Literally, the chat is the best. They bring up great discussions. I don't mind if people disagree with me. I don't mind if they agree with me. Whatever it is,
they bring up irrelevant points, though. And I don't mean any disrespect to anyone in his chat or something like that. They're bringing up really irrelevant points because it's not whether or not she made it possible for this to happen. It's whether she was grossly negligent. Grossly negligent. Is there an expert out there who says that this is what the state brought forward, saying this is that every parent makes sure that that their child who has any troubles at all has zero access to the gun? Do we see that? Because I don't even think that's true. I don't think that's true.
I love thinking, right? And the way I think about it is the 9,000 of you that are in the chat, this be a tough jury to get unanimity on, right?
This is a school. The school counselor testified that when they have late starting days, many of the students, and I'm sure many of those students we would probably consider to be troubled, many of their students go to shooting ranges. So tell me, in this environment here, whether this is something which is grossly negligent that the kid is able to get his hands on your gun when they go to shooting ranges before school. They have a whole process as to what to make sure the kids don't come into the school with the gun. So you tell me. I mean, that's why I'm saying that these questions here, yeah, if you live in a jurisdiction like I've grown up, I spent most of my life in, I grew up in the Northeast. Spent my whole life living in New York and New Jersey. We have far less familiarity with guns here, far less. So if you see a kid or a teenager with a gun, you're like, what the hell is happening here? That is not at all the culture in this part of Michigan, where they're taking prom pictures where they got holsters on their thigh like they're like in some James Bond star. I mean, come on. Like they think they're Laura Croft at when they're going to the prom. This is a whole different culture. And I think that we tend to get very centered on our own culture and what we're used to without having full appreciation for what the culture is there when we're trying to assess what's a reasonable parent supposed to do.
But the 9,000 of us that are here, what is it that's going through your head? Where is the line? Because Jules says,
here's a great point, by the way. He's saying it's deer season, November 15th to 30th. It's not 31st. There's no November 31st. But November 15th to 30th is deer season. I had no idea that's true. Okay. I assume you're correct, Brian. I don't know. My point is that's the difference in cultures. It's part of what makes America beautiful.
they didn't lock up the gun. A locked up gun can't kill. So if it was locked, but it just had like a window on it and he was able to break the window of the lockbox, or if the code, which the code here was 000, was the code to their locked safe. And the prosecutors act like, well, that was okay. You know, at least he locked some of them. Even
I don't even think that's the yardstick, because I think in this jurisdiction, kids have access to guns all the time. And most of those kids, tell me which teenager isn't mildly troubled. Show me the kid, because I want to meet him. Yeah, I don't think my kids are troubled. Okay? I don't think my kids are troubled. I mean, they have no troubles at all.
no, it was 000. But do we think we'd still be here if the code was 000 and Ethan Crumbley figured out the code, got the gun, and still did this? So is it just locked up, or is it locked up with a good enough code? And I'm just asking questions. Not trying to be argumentative. I am naturally confrontational, but this is not a negative confrontation. It's a let's learn, let's bounce these ideas and try to figure out where we think the line is. SC thinks both sides are blurring that line with what they should and shouldn't do in front of the jury. I absolutely agree with you. I've played multiple clips of the prosecutor making arguments on objections that I think are totally inappropriate. Pesky Pirouette said, when a gun is purchased, the name of the buyer has to be listed. Whoever's name is on that paperwork was run through ATF background and didn't secure the gun and ammo is responsible. Additionally, any other parent who knew the gun was loose also responsible. So there are lots of people that put their names on applications and get guns and then go sell it or give it to.
You want to make this comparison to a car, right? Which I think he's going to make that comparison.
Somebody has a gift or whatever, and they're absolutely not responsible for what happens with it. So is this just an apparent child situation?
I don't think that comparison is apt, because there you're divesting yourself from it, which is not what's happening here.
Because then it brings in the car.
Right.
If the parent owns a car, gives it to the kid, and something happens there, how much are they responsible? Now, civilly in Florida, they're absolutely responsible vicariously. Dangerous instrumentality, it's called, when you give your kid a car. And if you know they're a bad driver, they've gotten in lots of accidents or lots of speeding tickets.
But criminally, where they need to, here's the reason why civilly and criminally is so different. I don't think he's going to get on this.
But criminally speaking, that's where the difference lies. Nobody's saying there's no responsibility, especially civilly.
The reason there's such a big difference between civil and criminal is this. Civilly, you're going to have negligence, which is going to create liability. Criminally, you need to have the person who's the shooter has to have mens rea. They have to form intent. I want to do this to another human being before they're going to be criminally liable. Then you have to have criminal intent from the mother over here, or gross negligence from the mother over here. So because the shooter needs to have that mens rea, that now becomes the intervening act which severs the gun owner from the victim. Because all of a sudden someone is making a decision that we can never possibly foresee. You wouldn't expect anyone to make, unless they're, established as being a psycho, but you're not expecting them to make that mens rea intent to harm others. And if they do make that mens rea intent that's unexpected, that's why the gun owner should not be held criminally liable. I talked earlier about how if the shooter is someone who likely will form that mens rea because they're established to be a psycho, well, in that case, that creates more foreseeability for the gun owner / or parent, and thereby would be less of an intervening factor. Because what do you mean it's intervening? You knew the guy was doing it. Anyone would look at this psycho. Everyone knows he's going to shoot up a school if he can. So how are you saying, well, I didn't see that happening? Obviously, you should have foreseen it happening. But the point, and that's why this becomes a question of fact, is when we look at Ethan, and what we know about Ethan, does it seem like this is something that, or the mother was able to know about Ethan? Does this seem like something that, yeah, how did you not see this coming? And that's why this is why it brings us so much to like people talking about the school. It's like you're sitting here and you know all this stuff about him, and you didn't think he's going to do it.
But I think it's a great point. This is Pesky Pirouette's line. Amy Z, it's not illegal in Michigan to leave your gun unlocked. Right. That's the other thing. But there are certain things that.
By the way, when he said that's a great point, which I don't think it was a great point. I mean, I don't think it was. I'm going to share with you a little thing about podcasting, which is what do you do? And consider this, put yourself in the shoes of a podcaster, someone like in Peter's shoes or my shoes, okay? What do you do when someone sends you a nice, big, fat super chat, which is chock full of stupidity? And I'm not saying that's what Pesky Pirouette was doing. I'm not saying that. I'm simply saying we are put in such an uncomfortable position when someone just graces you with a nice cha-ching, a nice thing that you see it and you're like, damn, thank you. But the content of their super chat is so egregiously stupid that you're like, what do I do now? What do I do now? So you find some way to try to massage it as like, great point. And it's like, and I feel like I'm a sellout. I feel like you're buying my agreement with your idiocy. Just remember, the only testimony about the status of the gun was Jen's text saying the gun ammo and key to the cable lock that the gun was stored with were all hidden in different locations. Great point. All right, let me think about what you just said. Sorry. Just remember, the only testimony about the status of the gun was Jen's text saying the gun ammo and key to the cable lock that the gun was stored with were all hidden in different locations. I was unaware of that. I was unaware. See, thank you for the very generous super chat, H Coffee. Not everyone would agree with this perspective, okay? When people say, Trump bad, I understand why it is that people might think that he's somewhat objectionable. I get it. I understand it. I get it. But and the border deal, some people are going to feel that way. Some people are going to come to a conclusion that the border deal is beneficial to Americans. So I can understand, but I love how you added to the mix here, like divergent, because I think some people would disagree with this. Some would disagree with it, but yeah, great. Thanks for the super chat. And yeah, wow, that was we're not really dealing with that right now. We're not really dealing with that right now. But thank you so much. I really appreciate your support of the channel.
On their own are not illegal, that if you do them can become illegal. So I get that. But if we want to make it a law that everybody's got to lock their gun up, make it a law. It's not a law right now. Great thought-provoking comments and questions from you guys. I love it.
He loves it. Keep the super chat energy in the tunnel, sir.
I'm Jennifer Crumbley, and I could be here accused and sitting in her spot very easily. Jennifer
I'm going to back that up.
Now, when
she is literally going to put herself in Jennifer Crumbley's shoes. And again, I think
it's brilliant. I think it's necessary and brilliant. And this is where I disagree with with Peter.
Object with that to that. You can't do that as a lawyer. And number two, it all
In Florida, you can't, but there's really nothing in Michigan prohibiting that.
almost infers the golden rule. I could be Jennifer Crumbley. So could you, miss. So could.
So I don't even think that's really the golden rule. Golden rule I always understood as being do unto others as you would have done unto you. But I understand what he's trying to say. So I'm certainly not looking to nitpick him, particularly because I think that he's very intelligent. I know that he argues in good faith. So, but he is making the point that you're not supposed to say this could be you, even though there's nothing in Michigan's criminal law that seems to prohibit that. But she doesn't say that. But to me, this is the same thing as saying there's a meme. It's outside the strike zone of facts that are in evidence, but you can understand how it's highly relevant. It's highly relevant because this jury is being sent to deliberate what a reasonable parent would do. Well, the only way you can do that is by looking to yourself or to some other person who you might regard as a reasonable parent and say, what would they do in that circumstance?
You, sir, you could be James Crumbley. Got to be careful with that. Now, it's not the golden rule. Technically, it's not.
Oh, okay. He picked that up. Okay.
And you can say stuff like society or anybody could be Jennifer Crumbley. You can do stuff like that. Any mom could be Jennifer Crumbley. Any mom that has a bad week or a bad year or is going through stuff herself.
So I don't see why that's any better than her saying me. I don't see any difference between that and saying anybody. She's making herself anybody. I don't really see much of disparity there.
Could be Jennifer Crumbley. You can do stuff like that.
I took on this case pretty early on. I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now in my house, we don't have guns. I don't have guns, but I do have children.
So I think I probably would have left that part out. Again, she's testifying as to her own actions and what she does in her house and all that. Saying that to me, if I'm a juror, is like, exactly. So now anything you say about your parenting is very different than Jennifer Crumbley because she did have a gun. And not only did she have a gun, she didn't secure it properly and she bought it for her son as a Christmas present.
No, I agree with what Peter's saying here, but what he's really doing, if you listen to what he's saying, is you're shooting yourself in the foot by doing this. You shouldn't have mentioned that. Just leave that part out. Leave that part out, right? I mean, it's not that this is something that's breaching any sort of rules of ethics, but I agree with him, his critique here, that you're only weakening your argument by drawing this seemingly very important distinction between a parent who is of a kid who has access to a gun versus a parent of a kid who doesn't have access to a gun. Does seem to be shooting your argument in the foot. So I agree with him on that. But I'm pointing out the nature of his argument is not really a critique of her breaching rules. It's a critique of the fact that this was a stupid thing for her to throw in there. And he's correct. It was.
So if I'm on the jury, which I would never be, I concede that, I'm immediately differentiating you. This is what I do with cases, right? If another side cites a case, I'm like, here are all the reasons why it's different. So when you do something like this and you're going to now fully apply your life to Jennifer Crumbley, someone's like, yeah, but you don't have a gun in the house. You didn't buy a gun for your kid.
And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar.
So she's trying to draw the analogy between herself and Jennifer more closely by basically comparing a knife to a gun, which is an important thing for her to do in order to basically solidify that you should see her as being little different from Jennifer Crumbley.
Walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year.
She's testifying to facts to make her argument and theory that are not necessary. I'm not saying she's lying at all. I'm sure she's telling the truth, but that are not necessarily reliable or not cross-examined or not appropriate when you bring in your own life and experiences into it as a lawyer. She's basically making herself an expert witness on mothering and what's normal for a mom.
But you have to do this in a case where what else is someone supposed to do when the jury's going to go back there and try and figure out what a reasonable parent is? There is no expert testimony here as to what parents tend to do. There's no experts on studies that show what parents do or things of that nature. So they're left to basically think, okay, what would I do in this circumstance? And she wants them to be thinking along those lines. It's important. It's essential for her to be thinking along those lines. For them to recognize the gravity of what the state's trying to do here, and say that you can be held guilty. If the state has their way, you can be held guilty. You have no expectation your kid's going to cause massive carnage and destroy everyone's lives, but you're going to be now thrown in jail for it. That's what she's trying to bring home to them. I don't know what this means. I don't even know what that means.
And I do think that that's problematic. And again, the state didn't object.
Yep.
The judge allowed it.
Yep.
I'm just a guy here behind a keyboard saying it's not normally how it goes.
I would say that this case is a little bit different, though, because there's so much of trying to figure out what a reasonable parent would do. Think to yourself, when is there ever a case that's trying to decide what a reasonable parent would do? Because they're charged for like an act that has an intervening act. Because we have this intervening act here, that's why we sort of have to ask ourselves, what is a fair place to hold her in? And in order to come to that, you sort of have to ask yourself, what would you do? What would other parents do? So it's natural for her to do this in this context. It's essential for her to do that.
Here, and even years before, it would be so easy for me to be in her seat. With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day.
So some of that, I get it. And I think she's trying to be relatable and she's trying to make a point.
And she is being
there's
relatable.
a lot going on and she's not a helicopter mom. Basically, I honestly think the point she's trying to make here is she is a worse mom than Jennifer Crumbley. And again, it was pretty wild that this was her cross-examination. I'm sorry, this was her closing argument after last night's video where I said, I kind of feel like the theory of their case is we're all over the place. This is so hard. The state is so unfair. Everybody's doing stuff to us. We're just doing our best and we're kind of a mess. And that's kind of what I felt like they were trying to get the jury to like feel bad for them.
I didn't see that part of it. So yeah, I can't weigh in on that about the change in tactic.
And it kind of continued through closing argument with these kind of stories. And here's where it's going to kind of go off the rails. So she's like, yeah, my son talks to whoever on these video games. Like, that's kind of weird. Again, I don't know, no idea how old her son is or whatever, but that's not even the weirdest thing she's going to talk about that her kids could do, which again, in Cruz, if you think about it, we don't want to bring our kids into this. We don't want to bring our families into this. And she's kind of bringing them in because of these arguments, which is just strange to me.
And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone that I own, but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures?
Now, this got a lot of people to go nuts that she said she gave that example. And there's definitely a cringe element to it. Because, yeah, it's uncomfortable. And Runkle and I had a little bit of disagreement with this on Making Law Simple with David Helm, where we were dissecting that analogy she gives. Let's hear Peter's take on it.
If my son decides he's going to send some pictures back and takes a new picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable.
So to me, a couple issues, like gross.
Definitely. 100%.
Talking about kids that way.
Yep.
Number one. Number two, she literally just made an argument about how it is foreseeable. She doesn't check her kids' messages. She knows her son's into girls. When he gets over, this is foreseeably something that could happen. So I thought that was kind of weird.
So here's where I disagree with him on that. The point is, yeah, that's much more foreseeable then that's much more foreseeable than a kid deciding he's going to go shoot up a school. Much more foreseeable. And yet most parents would say, yeah, it does make sense that you should be held liable for that. So this is where I disagree. This is another place where I respectfully disagree with Peter, because that is her point. That is more foreseeable, much more foreseeable. Kids do all sorts of stupid things like that all the time. And I think she's basically banking on the fact that most people would say the parent should not be held liable for the kid doing so, because that's an intervening act. And even that, which is more likely, is considered an intervening act. And still no one would say, well, now you should be held liable for that. I think that's what her point is.
That you just talked about how it is foreseeable. And again, pick any other example, please.
And I agree with him on that. I don't like using this example. And Runkle went nuts over this example. He was like, you're going to have some jurors out there who are going to see this and they're going to be like, I can't believe you just said that. I'm finding your client guilty based on that. I think that's looking at jurors in a very simplistic type of way. Do I like the example? No, I don't. I think that there probably are other examples you can give which are a lot better. But she's trying to come up with an intervening act of someone doing something that's considered nefarious, which she's assuming the jury's not going to agree with her. I'm trying to think off the top of my head of, I mean, she could have used, I give my kid access to matches, all the time. I've shown him how to use sparklers. I've shown him how to play with. I've taught him the healthy way to deal with fireworks, and then he decides he's going to go burn down a building. Are you going to hold me liable for that? When I have no reason to think that he's going to do something like that. He had matches that were easily accessible in my house, and he decides to burn down a building, and God forbid kills 5 people when he does in the process. So you're going to say I should go to jail for that? How dare you give him access to matches? And there was even lighter fluid in your garage that anyone could have gotten their hands on. Anyone. So yeah, there are several examples she could have given rather than the cringy, like just no one wants to talk or think or start visual. It's just no. And it sounds like you're trying to make people visualize a situation that no one wants to visualize. So the objective should not be to make the jury feel uncomfortable by some visualization that you just put in their heads. So yeah, I agree. It's a poor tactic. It's a poor choice. I think her point actually makes sense, more sense than Peter seems to give credit for. I don't think it's as lethal a thing as Ian makes it out to be. I think it's a mistake. I think it's wrong. It's stupid, but it's not lethal. And I do think it makes a point. That's where I'm at on this. But still, it's like an unnecessary mistake, which just makes everyone feel uncomfortable. And no one ever wants to have their audience feel uncomfortable while they're listening to them unnecessarily. And this was unnecessary.
Any other example? Like a car or something else.
As well you should be, Aaron. As well you should be. Tons of lighter fluid. Matches probably too. It's all your fault.
Able to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well.
All right. I'm going to summarize parts of it and we're going to jump ahead a little bit. The World sent me emails explaining how to say cachet. Again, just more evidence that she is paying attention to what's going on the outside. We're
Even though it's really cash.
already at an hour. We'll get through it. I had an oopsie baby. Does that mean that you hate your kids? No way. I call them that. Basically, almost everything that they said Jennifer Crumbley did, she's like, I do that all the time. Does that make me guilty? Again, really using her own life, testifying basically to what she does and how it's normal or even worse than Jennifer Crumbley, and she's sitting in that chair. And it almost reads like, let me read you the definition of jury nullification and tell me if you think we're getting here, because she starts to talk.
This, by the way, over here, it's funny. I mean, look at that stack. It's like, in the event, just think about this for a second. In the event she needs something that's in the middle stack and 2 inches from the bottom, you think she's going to find it? I know she's got little yellow tabs to let her know what everything is. I don't think she's going to find it. I don't buy it. I don't buy it. I don't buy it. It'll take her like an hour to find it.
About how it's so unfair that this would ever even be a thing. If your kid does something bad, you should never be held liable is almost what she's saying. Now, she does work in foreseeability sometimes, like with that last terrible analogy. But jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about a social issue that is larger than the case itself, which she basically makes those arguments, or because the result dictated by law is contrary to the jury's sense of justice, morality, or fairness.
I don't understand the argument. He's about to make an argument that this is getting close to jury nullification, and I don't understand. I don't understand this argument. Maybe one of you can explain. If you can understand his argument, drop a comment down below. While we're here, please like, share, subscribe, especially on Rumble. Especially on Rumble. Like, subscribe, share, all that good stuff, please.
This could happen to me. This is how I live my life. This is what the text messages are like. This is what my life's like. And I'm really going to be criminally liable if my kid does this?
I'm not seeing jury nullification. I'm not understanding the argument of jury nullification.
I could be sitting in that chair. Is she almost admitting that the facts may fit, but they should still say not guilty because it's unfair?
I don't read it that way at all. I don't understand her argument to be that at all. Her argument is clearly this is when we're trying to figure out, you the jury are trying to figure out what is a reasonable parent would do. I'm the example of what a reasonable parent is. I'm hoping that I represent what a reasonable parent is. So I don't see that's arguing to ignore what the law is. I think it's an argument that the law dictates you have to let my client go. So I don't see the jury nullification argument at all.
That's also why I would have liked her.
There's no verdict yet. There's no verdict. The jury was sent home. I'm reviewing here Peter's assessment of closing arguments.
To work in, and again, very experienced lawyer, probably. I know I hate know-it-alls. I don't want to sound like a know-it-all. I'm just giving my opinion. It's one man's opinion. She didn't get objected to. She got through this. She could win this case. She could be the hero for Jennifer Crumbley. So I'm not saying I know more than her or anything like that. I'm just saying if she would have worked in the statute and how this actually fits into the statute and how this maybe makes it possible but doesn't directly cause the death, then I think it's no way it's jury nullification. But some of the arguments to me are starting to send off, and my dad said that to me too. It's like, it almost sounds like I was like, you got to hear this. So
I just want to point out, by the way, this is what I was talking about, that a lengthy jury deliberation is likely good for her. I'm just going to remind you, and look, it's 12 different people than what we saw in Wisconsin with Rittenhouse. It took them a week. Tons of video evidence exonerating him. Took them a week. Why did it take them so long when there's so much video showing the dude did nothing wrong? Like, he was amazing in the way he had showed such gun discipline and only shooting when his life was in peril. So, and still it took them a week. The reason I'm speculating, and this is 100% speculation, I might be right, I can be spot on right, or I can be completely wrong, because I wasn't in that jury deliberation room. I have no idea what they discussed. But I think that when you have a national case that is now being tried in a local jurisdiction that everyone knows, the whole country is looking at this, and the media has been portraying the defendant as being some vile creature, that to get all 12 of them on board to say we're going to cut this person loose takes a while. It takes a while. So are they ultimately going to get there? I don't know. I have no idea. I'm simply saying that the fact that they didn't come back quickly is likely, in my estimation, a positive sign for Jennifer Crumbley. because I think it's almost certain that they walked in there with a feeling of like, this is a terrible mom, and the only reason those kids are dead is because of her. So I'm taking this as a good sign.
I played him some parts of it, and he was like, what? So some of it does sound like jury nullification. Let me know, John, why don't you throw up a poll? Do you think there's any bit of jury nullification here in her argument, yes or no? I just want to know what you guys think after hearing the definition. And we're going to jump ahead just a little bit to them talking about, more of her own texts and issues with kids and her husband and all of that.
It does not mean she loved her son any less. If she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I sent text to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context.
A bunch of facts that she's stating to the jury that she's using in her argument that didn't come in, that are not in evidence. That's tough.
And I agree with him that she's really going very far. She's telling these lengthy stories. She's telling these lengthy stories about, the whole ghost thing, which just like, she could be making the whole thing up. We don't know. Is she making the whole thing up? I don't think she is, but she could be making the whole thing up. There's no testimony about it. It does seem to really be introducing facts that are not in evidence. That being said, DA has been letting that strike zone go wider and wider, wider and wider. Now she's telling ghost stories. Next thing you know, she's going to turn off all the lights and she's going to make a campfire there in the middle of the room. Started saying, "Ooh, it was a dark autumn night." Jury's letting her get away with it. I agree with Peter. That's really going pretty far.
But I don't really care that my daughter is crazy. I also got text one day. We have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad.
Just FYI, again, that's a good argument, I think. I think that's a good argument because, that stuff happens. Kids
It's a great argument. And the DA is letting her do it.
get mad. They say mean things. They say horrible things about their parents. So I do think it's a good argument. It's not that I don't think it could be effective. Usually some very good and effective. The golden rule is a great argument. If I looked at some mother that looked just like Ethan Crumbley's mom or is the same age or whatever, and I said, this could be you. Imagine if you were sitting there. Pick whatever one of your kids is the biggest problem child. If they did something bad, you could be sitting. That's a good argument. That would grip the jurors.
In this situation, how is that not a necessary argument? Because that's what precisely what they're going to be deliberating about, though. See, that's what I'm saying. To the extent it's allowed under Michigan law, this is exactly what they're going to be deliberating about. So, I think that she's obligated to try pushing this. I think her failure to push this would be poor advocacy on behalf of her parent, because that is exactly what these people are going to be doing. They're going to be self-examining themselves as parents. And I'll tell you something else. The fact that she points to herself and gives situations in her own life of her kid doing that or acting stupid or her calling her kid a psycho or things of that, which are all things that relate to things that came up during the trial, where Jennifer sent a text to her husband saying Ethan's weird. All these things, that doesn't mean that she recognizes that he's deeply disturbed. He shouldn't be around fire. All these things are things that these parents may look to themselves and start having questions about themselves. And when she now gets up there and says, this is what happens with me, it enables these parents to say, these mothers to say, okay, yeah, this mother has it also. Shannon Smith has it also. Shannon Smith is like me, and we're all like Jennifer. It's a very, very powerful argument. I think that these arguments are likely the strongest arguments that she's made as far as turning a jury towards recognizing how absurd it is to hold Jennifer Crumbley to this yardstick. It's very powerful. And especially if it seems like Michigan kind of allows this, kind of allows it, which it seems like they do, I would respectfully submit she's morally obligated to make these arguments. This is where I disagree with Peter. Now, and if there was an objection, I would make this point to the judge. I would say they're about to go deliberate what a parent does. What is the proper standard, proper yardstick? That's what the state has demanded by bringing these charges. The state has put forward, and if they objected and said she's not allowed to talk about herself, and let's assume that there was some sort of, that it was in violation of Michigan rule, I would, if I was Shannon Smith, I would turn back to the judge and I would say, Your Honor, the state, by bringing these charges, has now put into question what is considered grossly negligent parenting. Now, if we're assessing what Jennifer is doing is grossly negligent parenting, how can we do that without a yardstick of comparing to what other parents do? What's normal and natural for other parents to do? This jury is about to deliberate and figure out, try to decide, was she grossly negligent or not? Well, I want them to realize that that much as Jennifer has the conduct that she did, much of that is something that a typical parent would do. Perhaps they have done themselves. And that doesn't qualify as grossly negligent if that's what all parents do. That's what I would say back.
But you can't do it. You can't do it.
I respectfully disagree. I think in Florida, perhaps you could not do it, but I respectfully disagree with him. I don't think that it's not that she can't do it. I think that she must do it. And if it's wrong, well, in that case, you let them try to ask for a curing thing. At this point, I don't think there's anything ethically or morally wrong. Quite the contrary. I think she's duty bound to do this. What's so bad about jury nullification? The state is overreaching. Why let the process run over fellow citizen? But I'm from New Hampshire, so LFOD. I don't know what LFOD means. Let's freak out Darwin. That's what I get from LFOD. Let's freak out Darwin. I don't know how Darwin has anything to do with this. No idea what Darwin has to do with this. To me, it seems kind of crazy to bring Darwin up. But, and why would you want to freak out Darwin? But, yeah, jury nullification is, I don't think this is jury nullification. I don't see how it is if she's trying to explain to them what the yardstick should be as far as what's normalcy. Because we're in this gray zone as to what's considered proper parenting, careless parenting, grossly negligent parenting.
Arguments that are good arguments that you can't do.
We didn't have the right kind of chicken ramen. When we have 85, I like the number 85. When we have 4 other flavors of ramen, and there's about 100 other things she can eat, and I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And
those are so out of context. It's so out of context. It sounds petulant the way she says it. That's so out of context.
I'm driving home from court every day. I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-through and bring everyone a Coke.
Probably true.
I do stop and get myself a Coke, but I am not getting around with drinks every day for everyone. And I've realized it's easier to not answer the phone.
This to me was funny. I realized it's better if I just ignore him. Yeah, that's what I do. You know what? I'm getting drinks for myself. I ain't getting no drinks for you. No drink for you. No drink for you. No drink for you. I'm not even answering the phone because you might ask me for drinks. But I just wanted to know the combination to the garage. No drinks for you.
So you can find reasonable doubt from the context that the defense did
and
actually
that's what
provide.
I was saying. And look, maybe it's worse. Maybe it's worse because of the speed that it's being played. But man, her tone is just grating. Next. It's like, yeah, and I'm just not answering the phone. Next. Then they say he's a psycho. I call my kid a psycho. Next. It's like, whoa, easy. We get you're passionate. I understand that. Just like, dial it back, honey. Dial it back.
When Mrs. Crumbley got on the stand and explained to you her understanding of
This is what I was describing when I said I like what she's saying. I just don't like her presentation of how she's saying it.
ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on.
And to be fair, Peter is playing her, I think, at 1.5 speed. So that's why she sounds, it changes her tone, changes her cadence, as He's Dead Jim pointed out, does. So, but it does seem a little at this speed, it seems a little over aggressive. Look, if the jury doesn't come back with a verdict tomorrow I plan on going through cross-examination and closing arguments in full. This is just a little snippet of it that we're watching because I want to assess Peter. I want to show you why I disagree with Peter about some of the takes that he makes in this video. And again, that's not to disparage Peter. I think Lawyer does great work, great attorney, great person, great work, and genuinely phenomenal attorney. Really, really, really good attorney. Excellent. No buts. The objective of this video is to show you that even great attorneys, because it's an art, it's not a science, that there are different approaches and different perspectives as to what a good closing should look like. That's all.
All right, we're going to jump ahead a little further here. I'm going to hit some questions first. In my mind, Michael said it would be different if the shooting happened days after the council meeting, but it happened just a few hours after.
I don't want to go through, I want to skip past his dealing with these different questions that he was dealing with. Yeah, I feel it.
Wanted to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kid.
I'm simply talking about being effective. Your message is healthy. Your tone is alienating. But fair enough. It's a fair criticism. It is. I can't argue that one.
Were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified.
She's shocked there's not more bad stuff. Another thing I would not say about my criminal defendant, when there is bad stuff, there's no doubt there is bad stuff. We're sitting here trying to think, trying to be respectful, trying to understand the process. Where is the line? Because there is stuff here. Does it cross the line? To say you're surprised there's not more, to me, belittles at least some of what the prosecutor has. And she did say stuff like, they don't have anything. They brought these.
I think her point is that most of us probably have more bad stuff. I think that's her point. So I don't look at this as being as egregious as he does. But it's a fair point. I think he's making a fair point. But I don't think it's bad the way he does. Meaning, okay, that's one way to read it. There's another way to read it, which is if she was a terrible parent, the terrible parent that most parents would have something more. So why would anyone hold this against her when most of us have something, have a lot more terrible stuff in our own texts?
Stacks of evidence, and I did the Leaning Tower of Pisa. They don't got anything. They got nothing. That's why they had to tell you the house is dirty and blah, blah, blah. I think that's a decent argument. But here to say she thought there would be more. I don't know. I like the idea of saying they're cherry picking evidence and stuff like that, but not that you would expect more. It's just me personally.
And although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there'd be more evidence. They also run in text with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asks how they're all doing, and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness where my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part.
Michael RN said we need a federal Baker Act Marshman Act. I know it's not the first time you've commented that. So, I mean, it is interesting. There are definitely arguments on both sides of that as well, I think. Matt.
See, sometimes a $2 super chat, you can say, to a $2 super chat, you can say, no, you're an idiot. You're an idiot. If you want a link in here so we can debate this, I'm going to send you a link. I don't know if you have time or not. I'm going to send you a link, brother. I'm glad you popped in here. But I'm going to send you a link because I think I disagree with you about it being awful in the first third. Although I'll tell you that tomorrow I plan on actually going through the entire closing. So maybe that would be better. I plan on going through the entire closing tomorrow while we're waiting for jury deliberation. Now I'm just going through Peter's perspective on it, and I'm trying to show the audience that even though Peter is a brilliant attorney, that we can see things differently as to the strength or weakness or good argument versus bad argument or phrasing or things of that nature. And that's why I'm going through this here. But yeah, I'd love to argue with you about the first third there and go through that. You need to die. I'm kidding. I have much less of a strong opinion about pineapple on pizza than anyone else. So, yeah, okay. All right. I'm just saying, like, yeah, I didn't know you were streaming early. DM next time. That's not happening. What the heck is with that picture? What's with that picture? I don't. No. This is an offense against humanity.
Answer: you can't reasonably believe she saw the danger. DV for defense. Interesting.
Yeah,
Ash said
I want to
about your kid. Emily grade there. This is probably Brittany Spears.
She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to Common Ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone. And that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kid's school will not let them be there. And when they
That is her impeaching a witness with a fact from her own life that she's testifying to. That, again, I'm not saying she's lying, but the point of the witness stand is you can cross-examine, you can impeach, you can go get school records.
Hold on a second. I sort of zoned out for a second with what she said. Let me go back a little bit. I want to see what she said that he just freaked out about.
same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone. And that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because
So he's having a problem with the common sense thing.
when my kids are puking, my kid's school will not let them be there. And when they are
That is her impeaching a witness with a fact from her own life that she's testifying to. That, again, I'm not saying she's lying, but the point of the witness stand is you can cross-examine, you can impeach, you can go get school records, you can call somebody from her kid's school to find out if that's true. None of that happens when an attorney testifies during closing argument of facts that impeach other witnesses that did have to go through all that on the stand.
On this thing, I'll say Peter is spot on correct. 100% correct. Everything he said there was correct. She is impeaching them by her own and saying, don't believe them because this is what happens in my life. That is an improper impeachment. He's correct. I agree with him 100% on this part.
And this was just another example of saying what those people from the school said is not true. At my kid's school, they send kids home all the time if they puke. They could have sent him home. I think the argument that common sense as a parent tells you they could have sent them home. If kids get sick, they send them home all the time. You can make that argument.
Yes, precisely. You phrase it as like, ask yourself whether you think a school has zero opportunity to send home a child that they think is a potential health hazard to other kids.
Argument, but bringing in a fact that you're testifying to is the problem. I'm trying to show you where the lines are, where, you know, how
right.
what was kind of cringy and like I would have stood up and object to through this part. And Karen asked, did the prosecution not object because she's hurting the case? I don't think she's hurting the case. I think a lot of these are making good points.
She's doing great.
I personally think a lot of these are making good points. I know it's turning some people off, but
she brought up during cross that she asked them. This is the point, and I'm glad you bring this up because you're correct. I watched the cross. I watched the testimony of what's the name, Hopkins or whatever, the counselor. I watched that direct and cross, which I thought was a very important direct and cross, because he's pretty much the last person in the school who had an opportunity to stop him before the shooting happens and makes the assessment not to send him home. She did ask questions about, well, what if a kid's sick? And I thought it was stupid for her to raise it that way. I would be like, what if he said, I'm going to kill what if he had written in that thing, I'm going to kill the entire school? Would you have sent him home then? That's what I thought was a better way to approach it. So that I remember her asking this and thinking, I don't know why you're going down this road. There's much better ways to go down this road, which are more on point. But what she did wrong here was that she said, when they told you they wouldn't send them home from school, you should recognize they're lying. Why do you know they're lying? Because when I tried taking my kid out of school, when my kids are sick in school, they send my kids home. That is basically saying the reason they're impeached is because of my own personal experiences that there's been no testimony about at all. That's what makes it improper. And that's why Peter is making the point correctly. And everything he's saying in this criticism is spot on. It's a criticism of her for saying it. It's criticism for the DA for failing to object, because they certainly should have objected. And for her to say, you should know they're lying because what happens in my personal life, that is not proper. She can say, ask yourself if you think that makes any sense. Perhaps look into your own life, your own personal experiences. Does that make sense to you? That if you have a kid who's sick, that the school has no authority to send that child home? Does that make any sense to you when you're trying to assess their credibility? That's fine. For her to testify as to what happens to her in her real life, in her own personal experiences, that for the purposes of impeaching, for the purposes of making, for her, when she's giving the examples of like, I've called my kid psycho, that's now trying to get them to assess as far as what is a proper standard for parenting. At what point are we going to consider someone a gross parent, which is a very amorphous type of thing that the jury is inevitably going back there and trying to figure out for themselves. So you're giving them some sort of guidepost, which, okay, that's you're not trying to take down another witness. When she's trying to take down a witness and say they're lacking credibility because I'll tell you what happened to me, that's totally improper. So even though she brought up sickness, she didn't bring no one brought up anything about what happens with her in her school. Good point, but that's why it's different.
Melissa asked, why were the attorney-client texts allowed in? The court found that she inadvertently waived attorney-client privilege when she was on the stand. Nan said her taboo closing argument topics
I wanna-
aside, this lawyer is coming in too aggressively to the jury, very
Right.
off-putting.
And I
Jury
agree with Nan on this. Although it could be that the reason Nan's coming to this conclusion is the same reason I am, because it's being played in high speed. So it becomes the tone and style is much more aggressive and when it's being played at 1.5 speed. So it could be it's because we're watching it through Peter's filter of making it high speed, which I understand why he's doing that. I'm not critiquing him on that because it feels slow and long when you're watching it in normal speed. But but I came to the same conclusion watching it in 1.5 speed that Nan came to on this. But I don't want to sit here going through his super chats here, mostly because he's going to make you feel like pause. This is not a good freeze frame for Shannon.
one of the wilder arguments that she makes about poor Brian, who Miss Crumbley had an affair with, I was like, whoa.
What are you doing here to her, Peter?
And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Maloche has been put on a mission, which is you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Maloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified.
I mean, going hard at him, just calling him an idiot. Dominique, are you allowed to discredit witnesses? Absolutely. Usually what you can't say is, I think that guy was lying. And again, it's not like mistrial. It's all over. It's just if it's an objection, if there is an objection, the judge will probably sustain it. Don't call a witness a liar. You can say they were impeached. Are they credible? You can use other words that mean it. You guys, laugh when I say I don't like to call people liars. Like I try not to. I try to say, was that credible or not? But I mean, talk about catching a stray. Brian LaRoche, it's like, whoa.
He's an idiot.
She did a great job, I thought, using the argument that the prosecutor said where that teacher looked at Ethan Crumbley and she was such a hero and she stood right there and Ethan Crumbley didn't take her out and kept moving forward. And Shannon Smith said, yeah, because she couldn't believe Ethan Crumbley would do that either.
That's speculation.
And I thought that was a really good argument from a defense point of view.
It works.
All right. More personal experience about why Jennifer Crumbley is a better parent than Ms. Smith here as part of her argument we're going to listen to.
You might find, and I know the prosecution takes issue with this one, Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down life.
Okay, Amy, I'm corrected again. I don't know. So there's arguments on both sides, I guess. I've learned that it's like basically in everything in life. So now she's going to talk about how she is a hypervigilant parent, more hypervigilant than Shannon Smith is.
She's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day, checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen. She testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable.
It is powerfully beneficial to the mother. Powerfully beneficial to the mother. I couldn't believe it was him. You? Really? How can we hold Jennifer Crumbley as being grossly negligent in allowing Ethan to do this when even while it's happening, the adults who know him are in shock that he's doing this?
Great argument.
Mrs. Crumbley's hypervigilance.
Phenomenal argument.
When you look at how she takes him for medical appointments, they're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley,
I must need to go home and look. Tell us, are you going to stop at Popeyes on the way? Like you're telling us about like your plans for the evening. Well, kids, tonight I'm going to be doing mole inspection of your backs. She's a character. She's a character. She really is. She's a character.
She actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid, and she's just doing each thing she needs to do as a hypervigilant mother.
I don't like the characterization of Ethan as a bad brusher. You don't know he's a bad brusher. I have a theory. That some people genetically are more likely to get cavities than others. That their teeth are more inclined to rot than other teeth. It's a genetic deficiency that some people have. So it might not be that he's a bad brusher. It could be his DNA is that he's predisposed toward having cavities.
And yes,
I definitely think there's an argument as that's negligent parenting, not hypervigilant, doing it that way and enabling potentially, but see it both ways, I guess.
And she's framing it the way she's going to benefit her client. So
mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have 2 or 3 or maybe a bottle.
or maybe a bottle. You can't stop me. I'm about to drink a whole freaking bottle of wine. Okay? All right? That's what's going to happen. Don't even try standing in my way because I'm about to drink a bottle of wine. Okay? So just stand back. You all do your thing. I'm about to drink a bottle of wine. So good. So good. Oh my God.
Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along, like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this, Mom, watch this, Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child.
She doesn't sound like no hypervigilant mom to me. She described herself as a hypervigilant mom also. I don't know I'm calling Shannon a hypervigilant mom anymore. She's like, oh man.
And have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to.
They're bastards. They're bastards. They show pictures of a messy house. How humiliating for her. It really, to me, that's, as I said earlier, that's an indictment on her parenting. It is not that she's a bad mother and failing to be a housemaid, but that she's failed to raise him, to basically discipline him and say, if you don't clean your room, you're basically not getting, like, you know, your PS4 is going in the garbage.
She had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures of my house.
Why would you say that? Yeah, she's very relatable to you. She's a hoarder. Why? Why would you say that? I know you're trying to be relatable and be genuine. It's just the characterization, a hoarder. Oh my God. Oh my God. It's like they already know the first syllable of that is correct. They already know the first syllable of that is correct. Did you really need to throw in the second syllable? Oh, she's a big time hoarder. Why? Why do that? She's your client. Don't you like her?
Right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the
Literally, the case that they talk about in the Florida Bar Journal about can't talk about the sacrifice or how this is affecting your life or anything like that. And here we go. And there's multiple things that just are spot on in that.
Yeah, but here's the thing. I can't speak to Florida. You know Florida a million times better than I'll ever know it. But in Michigan, they say you can't talk about the impact that a verdict will have on your life, not that the impact that this trial has already had on your life. And the reason for that is logical. The reason there's such an important distinction there is because you don't want to create jury nullification. It's like, look, we really think she's guilty, but we kind of like Shannon for one reason or another, and we don't want her to be miserable, so we're gonna find not guilty. That's why you can't talk about future impact, but talking about past impact as far as like what I've gone through, it doesn't seem like Michigan has any problem with that. I don't know how beneficial it is, but as far as convincing the jury to go along with her, as far as it being an impropriety, I think that Peter's assessment here is harsh than I think is harsher than I think Shannon deserves.
Court and for these last few weeks, I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This isn't.
No, we covered that. We covered that earlier. And then I was showing how Michigan standards are far, far lower than Florida's. There's far more latitude that attorneys have in closing arguments. And I said, I think the reason he comes to some of his assessments is because he instinctively follows them because he has so much experience litigating, and he knows he keeps himself to a certain standard which Shannon routinely violates. But the point that I make is that she's in a different jurisdiction where she has a lot more latitude. So it's natural for her to be violating it, and indeed, arguably necessary for her to do so based on the nature of the legal issues that the jury is going to be deliberating, specifically trying to figure out what is a reasonable parent, what is grossly negligent parent. At what point are we going to attach that she's grossly negligent and this was foreseeable? So all these things are things that she needs to sort of insert herself or insert someone into to give them some sort of guideline to recognize that her client was not grossly negligent. So she's going to have to walk that line, and she has the good fortune that this case is being tried in Michigan, where her latitude is a lot broader. So I'm not critiquing Peter in the sense of saying, he's wrong. He's correct in Florida. I just think he needs to recognize that she's in Michigan and the rules are a lot laxer there.
Embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today.
And again, not that it's a big deal, but maybe someone there really likes the Salvation Army.
People are hung, pictures are hanged.
Maybe they like this lawyer more now that they know that she donates to the Salvation Army. Maybe not. Maybe not a big.
I don't like about this is that she basically Shannon makes me feel about her that she would forget to shower unless someone reminded her.
Deal, but that's why that stuff just shouldn't come in. Like, that's not part of the case. It shouldn't come in. We don't want to bring stuff like that in.
Would look just as bad as Mrs. Crumbley's, and it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done, or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her, watching trashy TV, than cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room. But regardless,
there you go.
Exactly. I think there's a difference in parenting there. I do. You guys let me have it if I'm wrong, but I feel like there's a difference in parenting there. Gabby said, regarding nullification, is SS's argument not the same as Mark Eiglar's saying that's a political prosecution to cover up systematic police failures? So what I would say is she does make that I think that's inappropriate to talk. And I think there was an objection in Mark Eiglar's closing argument where he made that, and they made him stop making that like public policy argument. But what I will say, the difference between this closing argument and Mark Eiglar's picked apart those statutes like crazy.
I don't know what case Mark Eiglar's was. Do you guys know what he's talking about here? Because I don't know what he's talking about. I'm kind of curious now.
And applied the facts and why this case does not fit into that statute. And the only reason we're here is for political reasons, because they should not be able to charge him with this based on what he did. He talked way more about the statute, I believe.
Was going to be to get those rooms in order.
It's a good point.
But
Oh, the
at that point
fucking
in the year when
officer.
holidays are coming up and you're getting ready for all of it and
So-
going through Thanksgiving,
Thank you.
it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing.
And again, pointing the finger at the school, other people being culpable is always a good argument
Yep.
for a criminal defendant.
100%.
Dana, so Peter, is your opinion that this would have been a strong civil case, but not a strong civil case because guns can be so deadly they should be locked in a case against the world when more strands plus game very with
Drove the car
the seventh. No, almost done.
experience at the rock range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she
It's an
didn't know it was
important
in
thing
the
for
house,
her.
Again, point the finger at James Crumbley.
Yep.
but she is not the
Yep. We both agree. That's definitely something that Shannon should be doing.
person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment.
Now, this is an interesting thing because this is the sort of thing which in some jurisdictions is improper. And in theory, a DA could raise, like you can't raise that. But Peter seems to be okay with it.
The media knew. And then the prosecution came out with a big press conference announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't.
I think that was a pretty good point. I know Shannon Smith is probably watching a lot of stuff. She probably is not going to be very happy if she watches this, even though I feel like a lot of what I said is that she's making good arguments. Just for me, a Florida trial lawyer, a lot of them would be inappropriate, but I think that's a good point and appropriate that they wanted to turn that into a media charade. That's why they set it up the way they did. That's why they didn't help with a.
Well, Shannon, if you're watching this, which is possible, if you are, I think you did great. I think your closing was great. Your whole trial style leading up to closing, I had some issues with. I did, but I think your closing was like, I give it a 90 out of 100. Really, really great, and in a very difficult situation too. So kudos to you.
Surrender and make it normal like we've done in a million cases, but instead they turned it into a big charade and made it look like they were fleeing. I also really liked the end of her closing where she said, this is not the only reasonable doubts. There's a blank card and you can come up with your own reasonable doubt, something like that. Then the prosecution gets up for rebuttal and they say,
we can debate that tomorrow. I'll send you a link tomorrow. I'm almost done here, but we can debate that tomorrow when I'm doing jury watch.
Or she did mention one more time, their texts read a lot like my husband and I's. You shouldn't consider what the lawyers do in their life was like the first thing the prosecutor said on rebuttal. I'm like, why didn't you object then?
Yeah.
If the jury shouldn't consider it, it shouldn't be allowed to be argued to the jury.
Assuming they're correct. And if they're not correct, then you shouldn't be making that claim in your rebuttal.
But they didn't object, and therefore they waived that as an appellate issue. And if it's a not guilty verdict, they're not going to appeal it anyways. They can't. For the most part. Basically, she said, we don't need to prove this. We don't need to prove that, which I don't ever think is a good look for a prosecutor. And I think that shows a good closing argument by the defendant. If they're like, we don't need to prove that they fled. We don't need to prove this. Like, but you've been saying all this stuff. So now are you saying that you didn't actually prove it and it didn't actually happen? I know that's not what they're saying, but sometimes it can sound like that to a juror. And then I just want to play an objection. Another thing that Shannon Smith did that somebody said here, Lisa, she then said probably that all the prosecution witnesses were pressured to lie. And the prosecutor's like, I have to apologize and I have to speak on behalf of all law enforcement officers for their credibility. And Shannon Smith objects again one last time that we get to see a little sparring in this trial.
Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. But standard and what I have to prove is not that she knew that her son would go shoot up school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty.
I'm not sure. I disagree with what the legal standard she's putting forward here.
She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability.
Grossly negligent, not just careless, grossly negligent.
The ordinary care was required.
And that's the point. What steps did she take? What steps did she not take? Good argument by the state. Jennifer Crumbley.
Whatever you think is reaching that, now we reach negligence, it has to be more than that to be grossly negligent.
They would say she hid the bullets, locked the gun, or James Crumbley locked the gun.
See, I would have objected, if I was Shannon Smith, I would have objected to this point in closing that she's misstating the law, like really badly misstating the law and confusing the jury as to what the law is. And that's an objection that gets sustained. You can even get like a curing statement from the judge to basically say what the prosecutor just told you is wrong. It's not simply negligent. It has to be grossly negligent.
They went to the school. School didn't make them come home. She loved her kid, got him braces, whatever. And those were some steps, I guess, is what they're arguing.
The smallest of things. The smallest of things.
I plan on going on tonight, yeah.
I apologize to the law enforcement in this room and any listening that I have to stand here and defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
I'm objecting because I'm allowed to argue based on what's in evidence, and Ms. McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
Overruled because she's not saying your argument is improper.
Right.
She's saying your argument is wrong. There's a difference. You object, tell them.
Peter's correct here. Peter's correct. And she should be overruled because she was wrong. She just sort of objected to the legal standard that was being set forward by this judge, by this prosecutor, which that was completely messed up.
Stop doing it if you think the argument's improper. If you think it's wrong, you give the other side. And she gives the other side talking about the integrity of these witnesses and law enforcement, how hard it was when you said they were lying or pressuring people or, doing all this other stuff. This is how closing arguments go. This is why there is a rebuttal.
Police officers argue about these witnesses. Police officers should argue about
the exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence check, they were all in some sort of conspiracy. That's what you have to believe.
No, you don't. No, you don't.
Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do.
So,
All right. I'm going to hit a couple questions here now.
I think this
John, again, per this case, the jurors saw all SS closing.
That's the end of it. So I'm not going to go through, I'm not going to sit through his super chats and his responses to that. Again, those of you who joined late, this was the reason that I did this was so that you all can appreciate the distinction between the way different experienced litigators look at a closing argument, and to point out to you that even though I have deep respect for Peter and his litigation skills, and I know that he's a seasoned, great attorney, very smart guy, and makes points in good faith, and he's someone that I recommend everyone should follow because I think He brings information in ways that are admirable. And he does great work as a YouTube content creator, in addition to being a great lawyer. So none of this was designed to be as a takedown of Peter. It was simply to display to you you can have two great attorneys who are looking at the same piece of work and see it completely differently, because this is not a science. This is an art. It's an art of how do we convince 12 people? How do we work within the rules of the jurisdiction to go to do as much as we can to convince 12 people? And what's more likely to be successful, to convince those 12 people to see our arguments our way rather than the way it's being presented by our adversary. So that's the reason that I wanted to do this share this perspective and go through his video, so I can sort of show you where I diverge from his perspective. It's not at all a lack of respect for Peter. Quite the contrary, I have great respect for him in every way imaginable. So with that, Smith's motion to not name Ethan Minor and her example are likely holdovers from his specialty practice experience as a criminal's essay, a defense attorney. And this is one of the things that I hit on many times. I thought strategically it was a poor choice on Shannon's part to leave out Ethan's name. I felt humanizing Ethan and making him that intervening, unexpected agent, that he was just Ethan. Until the shooting, everyone always knows of him as the shooter. Until the shooting, and in Jennifer's mind, when she's making all these decisions as to what type of parenting to engage in, he's just Ethan, not a shooter. He's just another kid who, in most respects, is little different from any other kid. A little troubled, yeah, most teenagers are, and that I think would have helped her client a lot more than having him identified as Jennifer's son or shooter or whatever. Crazy psycho person. So you're saying it's likely a holdover from her specialty practice as a criminal? Could be. I don't know. Could be. But I think it was a terrible mistake. This is like moot with real consequences. It is. It is. Yeah. That's what makes it compelling, I think. I saw what you did there. Says you're a great attorney. I don't know what you're talking about. I know what you're talking about. Anyway, I thank you all for joining me. I think I covered everything here. I think we did well. Tonight I'm going to be streaming, probably at 10 o'clock. That's the expectation. Have no idea what I'm going to cover. If you have suggestions, in that case, come to goodlogic.locals.com. Goodlogic.locals.com. Say, Joe, get on this. Get on this. And I tend to serve the people, especially if I agree with you that it's something that people want to hear me weigh in on. So goodlogic.locals.com. And tomorrow I plan on doing some more work where I'll be doing jury watch, and I plan on watching and while we wait for the jury, I plan on reviewing cross-examination of Jennifer Crumbley as well as closing arguments in full, where I'll be able to give you a more fleshed out, and I'll probably try to get Ian in here for the first third of Shannon's. I'll try to let him know. I don't know if he's still here, Runkle, but I'm going to try to get Runkle in here so we can watch that first third together if he's willing to come and assess the part that he thought she didn't do well, that I think she was fine. But till then, I look forward to seeing you all in roughly 3 hours. Till then, stay happy. Even though I'm not around, you can still stay happy. You know how you do that? Eat some bugs. And as always, my friends, Godspeed.